The Royal Commission is now in session. Please be seated.
Yes, Mr Scott, I'll just take the appearances.
May it please, I appear with Miss Marsh for the first witness of the day.
Ms Hogan-Doran?
Commissioner, I appear with Mr Kaplan for the Commonwealth.
Yes. Thanks, Mr Flynn. That's it, is it? Yep. Thank
I believe
you.
so, Commissioner. Before the first witness is called, can I deal with a matter of housekeeping arising out of Mr Philp's evidence from yesterday, which is that having now heard his evidence, I'm content to proceed on the basis that I don't require Miss Essex for any further questions, and I understand that is Miss Alison Essex, who was stood down when she gave evidence but not released from her summons. I understand that Miss Hogan-Doran doesn't require her for further questions, and I'd ask that Miss Essex be released.
All right. Well, Miss Essex is excused from further attendance.
Thank you, Commissioner. Can I tender then the exhibits on the list for the day, starting with Exhibit 6849 through to Exhibit 6873?
Is that the entirety of the list, or?
That is for the next witness. There's...
Yes, those exhibits, 6849 through to 6873, are admitted according to the description in the list.
Thank you, Commissioner. I call Barry Jackson.
Mr Jackson, will you take an oath or an affirmation?
An affirmation.
Right, would you stand, please?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Yes, Mr Scott.
Mr Jackson, would you please inform the Commission your full name?
Barry Raymond Jackson.
And you were provided a notice to give information in writing and produce documents dated the 27th of February 2023?
Correct.
And you produced a statement in response to that notice dated the 3rd of March 2023?
Correct.
Are the contents of your statement true and correct to the best of your knowledge and belief?
It is.
Thank you. It's the case, isn't it, that you presently hold the position of Managing Director of Defence Housing Australia?
That is correct.
Prior to being appointed to that role, you worked at the Department of Human Services from the 19th of August 2013 to 12 May 2019?
That is correct.
Okay. And during your time in that department, you acted in the role of Secretary of that department on a number of occasions?
That is correct.
One of those occasions being the period from 22 December 2016 to 9 January 2017?
That is correct.
You say at paragraph 18 of your statement that you weren't involved in the Robodebt scheme until you became acting secretary from 22 December 2016 to 9 January 2017?
That is correct.
And you became involved in it, though, during that period. Is that right?
That is correct.
And that was in the context of significant media attention on the scheme, correct?
That is correct.
And it was in the context of some inquiries by the relevant ministers, Minister Porter and Minister Tudge, in January. Is that right?
Probably possibly started December, but certainly over the December-January period.
Okay, thank you. Now, you've got a folder in front of you, Mr Jackson.
I do.
There's a document I want to ask you about behind, I think, tab 14 of that folder. A document ID skr.001.001.0054_R, exhibit 5830.
I have that.
Thank you. And do you agree with me that that first page comprises emails between yourself and Miss Melissa Golightly on the 6th of January 2017?
Correct.
And may we take it that is the document which you deal with at paragraphs 35 to 39 of your statement?
Correct.
Thank you. If we call out your email at the bottom of the page on the 6th of January 2017 at 5:24 p.m.
Yes.
All right. So you say, hi to Ms. Golightly. Did we find out whether the averaging is in the ledger or the guidelines, and if so, where?
Correct.
Is that right? Thank you. Can you tell us the context in which this email was sent?
It was an email that I sent following up a verbal question that I'd posed to Ms. Golightly along the same lines as to there's been frequent commentary around we've always done it this way, this is how it's always happened. And I asked the question to actually see some evidence to show that it actually was allowed for either in guidelines or legislation to find out the basis for the ongoing statements.
Okay. And when you say there was frequent commentary around we've always done it this way, what was it that was that commentary about it having always been done this way? I'm sorry, my question was imprecise. What was it you're referring to?
The averaging.
Okay.
Yeah.
So the averaging to calculate income.
Correct.
For the purpose of working out fortnightly income in determining social security.
Correct.
Okay. And when you say there was frequent commentary about that, can you say commentary from whom?
It would probably be every meeting that I went to where the scheme itself was discussed was words to the effect, this is how we've done it always, it's been done this way for 30 years. And it sort of would come from the likes of Ms. Golightly, Ms. Hartfield, Craig Storin and others who were the principal people involved in delivering the program. And I openly admit that when I hear the phrase, we've always done it that way, it's normally a red flag to me to ask, why?
Okay. And the question, part of the question in this email is, did we find out whether the averaging is in the ledger? Ledger being what?
Legislation.
Okay. And what was it that you were seeking by this email?
My expectation was that there actually had been, given that the program had been going for some years, that there was some advice that would actually clearly state that this is legally how we are allowed to do things.
So when you say advice, what type of advice are you referring to?
I'd be looking for an opinion from, probably in the first instance, the AGS or the like, that basically advised that in constructing the legislation or constructing the process, that the legality or otherwise had been considered.
And why would you be looking for advice of that nature?
To justify in my own mind that when we constantly go and tell people it's been done this way, that it actually is the appropriate way of doing it.
All right. You ceased acting in the role of Secretary on the 10th of January 2017?
Midnight the 9th, to be technically correct.
Okay. Prior to that point in time, was advice of the nature that you sought produced to you by Ms. Golightly or others?
No, because I think at the top of that email, you'll see that Ms. Golightly did respond to my email, saying that she had referred the matter to Paul Mensington Bay, I think, seeking advice, and that he was looking at it. And I received no subsequent advice prior or after my acting ceased as to how that request had progressed.
Okay. Was there a handover between you and the substantive Secretary, Ms. Campbell, after you ceased acting?
There was. It was a verbal discussion between Ms. Campbell and myself. It covered a range of issues, obviously, not just issues around the Robodebt. Clearly, Ms. Campbell had been in contact with Ms. Golightly and the Minister Tudge prior to her return and was therefore well across a lot of the issues, so it was not an extensive handover. And I think within the evidence pack that, and in my statement, I have identified a number of emails that support that statement and various conversations. So it was a short reference to the fact that there had been significant. I did provide, as I mentioned in my statement, I provided a short summary of the fact that meetings with the Minister Porter and Tudge, most recently the previous day, had occurred, and sort of the nature of those, which was primarily around how the system operated. And I did mention that I had raised the question about the basis for the averaging.
All right. And when you say you had you indicated that you had raised the basis for the averaging, is that what you're referring to in paragraph 42 of your statement? Your statement, by the way, is behind your tab 2 of the folder.
Thank you. That's correct.
Okay. Can you assist us with any more detail about the words you used in raising this issue with Ms Campbell?
Other than as I've outlined already, probably I couldn't give you sort of a verbatim approach, response.
Okay. Having made the request of Ms Golightly on the 6th of January that we've discussed, who apart from yourself would have authority to withdraw that request?
Whilst I was acting secretary, no one.
And then after that?
I mean, that could be to actually withdraw the request. That's an interesting question. I don't think I could actually directly answer that, but I'd be surprised for whether or not anyone other than the secretary themselves could withdraw that request.
Okay, thank you. Can I just ask you to go to your tab 10, Mr Jackson, doc ID CTH.475.0028.0076_R, exhibit 6856.
Yes.
You referred in your evidence earlier to emails you'd identified to indicate communications involving Ms Campbell while she was still on leave.
Correct.
And do you see at the top of this page an email to yourself from Ms Golightly on the 7th of January 2017?
Yes.
Referring to the fact, or referring to Ms Golightly saying that she was then on the phone with Kathryn.
Yes.
Kathryn is Ms Campbell.
Correct.
Is this one of the emails you referred to in your evidence earlier?
It is.
Okay. And then if we go to your tab 22, Mr Jackson, exhibit 6866, doc ID CTH.475.0028.0423_R.
Yes.
And can you see an email chain there in which Ms Campbell is included, and indeed in which Ms Campbell is sending an email on the 8th of January 2017?
Yes.
Is that another one of the emails that you referred to in your evidence earlier?
It is.
Thank you. Finally, could I ask you to go to your tab 7, Mr Jackson, doc ID CTH.4750.0028.0039_R, exhibit 6853. you have that, Mr Jackson?
Yes.
Do you agree with me that's an email chain culminating in an email from Ms Golightly to the Minister dated the 8th of January 2017?
It is.
And it refers to a Peter Martin column? Last sentence.
Yes, it does.
Okay, do you have a recollection of what that column was?
No, I don't.
Okay. Could the witness please be shown Exhibit 4321, Doc ID RBD.9999.0001.0369? This isn't in your bundle. Mr Jackson, it's not in there.
Oh, it's not, sorry.
Can you see that purports to be, it would seem, an article from
Yes.
Mr Martin. It would seem first published on the 6th of January 2017,
Yes,
headed How Centrelink Unleashed a Weapon of Mass Destruction.
yes.
We go to the second page. And you can see, fourth paragraph, the sentence commencing what's important in this description. You see that?
Yes.
And then we call out the paragraph just before, yes, there, those words, many of the automated systems are malicious, created to do harm in the guise of providing a service. The formula used by Centrelink produces consistently false estimates of debts by dividing by 26 the annual wages employees report, paying in order to overestimate income received during the smaller number of fortnights claimants get benefits. See
Yes.
that? Does that refresh your memory at all as to what was the Peter Martin column in the email from Ms Golightly we just discussed before?
Those particular phrases don't. The headline referring to weapons of mass destruction refreshed my memory that that particular article had been through, but there was a significant volume of articles at various stages. So that particular clause does not make me relate to this particular article as opposed to any others.
Okay. Commissioner, that's the evidence of the witness.
Thank you. Mr Flynn, did you have questions?
Yes, if I may briefly exercise the leave that was earlier granted.
Certainly.
Mr Jackson, my name's Flynn. I appear for Ms Kathryn Campbell. Now, you prepared your statement dated the 3rd of March 2023 in the space of 2 days, correct?
Probably a day and a half. I didn't actually receive the emails until about 11:30 on the Friday before the 4 o'clock deadline.
And you prepared that statement under pressure of time about events which happened more than 6 years ago, correct?
I prepared it within the time constraints I was given. Yes,
And that was a day and a half, correct?
correct.
Now, you knew when you were preparing your statement that an important matter was the lawfulness of income averaging, correct?
Correct.
And do you agree that it was difficult for you to recollect any of the events to which your statement related, except insofar as you were prompted by documents you reviewed?
No, because I do not accept that premise, no.
Well, do you remember a moment ago you didn't remember what the Peter Martin article was about until you were prompted with the article itself?
I would not put remembering one of multiple media articles in the same category as remembering what was happening during my time as acting secretary.
Now, insofar as your verbal handover to Ms Campbell on her return from leave on the 10th of January 2017 is concerned, you've said in paragraph 40 of your statement that the details you provided in relation to the Robodebt scheme were limited, correct?
Correct?
And you gave some evidence earlier that it wasn't a particularly detailed briefing, correct?
That's correct.
And in part, the reason you didn't provide a detailed briefing is because you assumed Ms Golightly and other DHS staff who knew the detail of what had been going on in Ms Campbell's absence would be available to update Ms Campbell, correct?
In addition to the fact that there had been numerous emails and telephone conversations between those parties prior to that event, so one in combination with the other would be a fair assessment, but not in isolation.
Now, you agree that you can't remember whether the verbal handover to Ms Campbell was over the telephone or in person?
I have no firm recollection of that, no.
And I suggest to you you don't have any firm recollection of that handover at all. Do you agree?
No, I do not.
Well, you don't remember whether it was over the telephone or in person, do you?
I don't believe that that actually correlates with whether I remember the handover discussion itself.
You don't have any notes of that meeting, do you?
No, I do not.
And I suggest to you that the only recollection you have of that meeting has been influenced by the documents you reviewed for the purposes of preparing this statement. Do you agree?
I reject that premise.
Could I take you, please, to Exhibit 5830, which is SKR.0001.001.00054?
And where might I find that, please?
It's up on the screen, Mr. Jackson.
Thank you.
I think it was also in your folder, or...
Tab 14, I believe.
Yes.
Thank you.
Now, this is the document that you refer to in paragraph 35 of your statement, correct?
Correct.
And you reviewed this document for the purposes of preparing your witness statement, correct?
It was part of the bundle of documents I was provided, yes. It was one of the emails in the 815,000 emails that I received, yes.
And you read this document before you formulated the words of your statement, correct?
Incorrect.
So you're saying you formulated the words of your statement and then you read this document. Is that your evidence?
The actual words of my statement were formulated combining my recollection of having asked the question with confirmation of this email.
And what question are you referring to, Mr. Jackson, in that answer?
That I had asked Ms. Golightly verbally what was the legal basis for the averaging and the ongoing continuous statement that we've been doing it this way for 30 years, therefore it's okay.
And that was a recollection you say you had before you read this email, is that right?
Sorry, I didn't hear the question.
That recollection you just told us about, that was a recollection you say you had before you read this email, correct?
That's correct.
And I suggest to you didn't have any other recollection of matters relating to this email before you read the email. Do you agree?
Any other recollections regarding what?
Regarding this topic of averaging.
I'm sorry, I don't understand the question.
The only recollection you had as to what happened in relation to the topic of averaging in January 2017 before you read this email was the matters you just gave a couple of answers ago. Do you agree?
No, I think I'm quite comfortable in suggesting that the discussions around averaging had occurred in multiple forums, again being justified that this is how we've always done it, not purely as a result of this particular email.
Mr. Jackson, could Mr. Jackson, I'll withdraw that. Could Mr. Jackson please be shown paragraph 42 of his statement?
You've got it in the folder in front of you if you'd prefer to look at a hard copy, Mr. Jackson. It's at folio 2, I think.
Yes, thank you very much, Commissioner. I appreciate that. It's on the screen, yes.
You see that, Mr. Jackson?
Yes, I do.
And I want to suggest to you that the wording that you came up with in paragraph 42 was formulated after you'd read the email, which is Exhibit 5830, correct?
The words were formulated after, but that does not preclude the fact that I had a memory of it prior.
And I want to suggest to you that paragraph 42 is a reconstruction of what you think you said based on your review of Exhibit 5830 and doesn't represent an actual recollection that you had at the time of your preparing your statement of what you said to Ms Campbell over 6 years ago. Do you agree?
I do not agree.
And I suggest if you don't even know if it was a telephone call or an in-person briefing, you would not recall that level of detail. Do you agree?
I consider the two to be separate concepts.
And I want to suggest to you that paragraph 42 of your statement is a reconstruction based on what you now think you ought to have done, having read the 6 January 2017 email exchange with Ms Golightly and being aware of the importance of the issue of the lawfulness of averaging, rather than representing any recollection of what you actually did. Do you agree?
I do not.
And I want to suggest to you that if you had been concerned to brief Ms Campbell as to the exchange you had with Ms Golightly, the simplest thing to do would have been to forward that email exchange to Ms Campbell. Do you agree?
I think that's a hypothetical question.
Do you agree it would be easy to forward, it would have been easy to forward that email exchange to Ms Campbell?
The email exchange was, from memory, attached to an email that contained about 45 media articles to it, and I would not consider it necessarily appropriate to forward such an email. At the time, I was the acting secretary and had the authority to ask the question which I asked. I was entitled to receive a response, which I did receive. Should I have undertaken to forward that to the incoming substantive secretary with the benefit of 6 years hindsight? Possibly. At the time, I chose not to.
I want to suggest to you the fact that you did not forward the email shows that you didn't regard it as an important matter at the time, and you did not tell Ms Campbell about it in the terms of paragraph 42 of your statement. Do you agree?
I do not.
I don't have any further questions, Commissioner.
Ms Hogan-Dory?
No, Commissioner, thank you.
Mr Scott?
No questions from me. May the witness be excused.
Yes. Thanks, Mr Jackson.
Thank you very much.
Mr Gregory will take the next one.
Yes. Oh, God. Okay. Now, Mr Gregory, while Ms Campbell's getting settled in, do you have exhibits?
I do. I tender exhibits on the draft list marked 6874 through to the end of the list, which is 7074.
All right. Those exhibits will be admitted with the numbers they bear in the schedule. Ms Campbell, I'm not sure if you took an oath or an affirmation, but whatever it was, it still binds you. You'll understand.
Yes, Commissioner.
Thank you.
Ms Campbell, since you last gave evidence, you produced a further statement more recently dated 3 March 2023.
Yes.
All right. And that was not in response to any notice to do so, but one that you volunteered.
Yes.
Thank you. That's the one on the screen, and I take it you confirm that statement is true and correct?
Yes.
Ms Campbell, can I take you back to 30 December 2014, your meeting with Minister Morrison soon after he came into the DSS portfolio minister role. You met with Mr Morrison, I think, at the Commonwealth Parliamentary Offices in Sydney on that date.
Yes.
And also present was his Chief of Staff, Mr Charles Wan.
No, I can't recall.
You can't recall? Since you gave evidence, Mr Wan has given evidence and produced a file note of that conversation, that meeting between yourself and Minister Morrison. Could I have Exhibit 5206 on the screen?
Could the document be enlarged, please?
Yes, if we could have it, paragraph 6A enlarged. Mr Wan, you can see, says there that he located notebooks and reviewed the following entries which were relevant, and he refers to the meeting between yourself and then Minister Morrison, 30 December 2014, which he attaches as Annexure A to his supplementary statement, and he refers to the entry he made in respect of an integrity package. I'll ask that Annexure A be produced on the screen. These are Mr Wan's notes of that meeting between yourself and then Minister Morrison. He gave evidence that he highlighted in purple matters that he thought were relevant on his review of those notes. That is, he added that highlighting recently. There is a reference to compliance, JSA, check going to interview as the first dot point, and then it continues. You'll see an asterisk a little way down the page which says compliance plan and outcomes. ICT is also a dot point there. The highlighted passage which next appears, he said, was 1.1B for billion over 7 years, pay off within 4 years, and he thought that was a reference to the dated Centrelink IT program which had been in existence for 30 years. You can see the note above that. Then at the bottom of the page there were highlighted passages which include the word challenges, below it IT, and below that non-compliance, and there was a reference to gangs, and I don't think he could interpret the next note. But across from there, a part which was not highlighted was in the bottom right, or bottom middle of the page, which is now enlarged in the centre of the screen, policy dash reliance on payment entitlements based. And then over to the top of the next page, under the heading Most Excited, he highlighted MyGov website, Move Everyone Online, and below that, integrity package and IT systems. Now, I appreciate you haven't had the opportunity to review that note before you gave evidence, to my knowledge, but those notes sit generally well with your recollection of the topics that were discussed at the meeting with Minister Morrison.
Yes.
The reference to policy and the reliance on payments and entitlement-based, are you able to say anything more about that entry on that note?
No.
As that note appears, it would seem that that was information provided by you to the minister rather than the new minister to you. Does that sound right? Reference to policy in the entitlement space?
If by raised by me you mean that I discussed policy-based, yes.
All right. What followed from that meeting, as you addressed in your earlier evidence, was various meetings between yourself and other staff at DHS in early January 2015 with respect to the question of identifying savings measures or a range of compliance measures which might fit the minister's request.
Yes.
And from that point, a brief to your minister, Minister Payne, was developed, marked B1539.
Yes.
Call that yes. There are a range of folders in front of you, Ms Campbell, but the reference to B1539 is behind tabs 5 and 6, which are exhibits 1938 and 1942. And I just wish to confirm, sorry, it'll be volume 1 and 1 of 3.
One of
Hopefully the tabs will commence at part 1 and number 1 and following. And the documents on the screen appear at tabs 5 and 6. Thank you. I just wish to confirm with you, Ms Campbell, that you were informed on 15 January 2015 that the cover brief for B1539, together with the brief itself, was sent to Minister Payne's office and that it incorporated the changes discussed between you and Ms Golightly. You see that?
yes.
The attachment as it's been produced in the material to the Commission appears in markup text, although I can take you to, I think, the original or the final version of it, if you wish, that is without markup, but you will see at page 14 of 30.7952, the reference to the relevant PAYG proposal, which expressly provided in paragraph 1B to, if that could be called out, thank you, to the digital approach, which would use an income smoothing methodology to apportion the customer's income over the time of employment rather than the current cumbersome process whereby the department has to determine and apply income on a fortnightly basis. Do you see that?
Yes.
And that the option provided to the customer in the terms of this proposal was set out at paragraph C, which created an optional response. And at paragraph E, you'll see there the brief referred to the possible need for legislative change by use of the sentence, "It may also need change to legislation." You see that?
Yes.
And in the provision of that brief to Minister Payne, was it the case that you were endeavouring to comply with the request given to you by Minister Morrison on 30 December 2014 to develop a range of compliance measures and explain the current arrangements?
Yes.
You may recall it, but by the time the executive minute was prepared for Minister Morrison on 12 February 2015, that phrase, "it may also need change to legislation," was converted to a more definite proposition that the introduction did need a change to legislation. Do you recall that?
Can I go to where that is, just so I can refresh my memory, please?
Certainly, behind tab 11. Exhibit 2669. Page 10 of 17, the last dot point, dot 0046.
Yes.
Yes, thank you. And you understood, of course, by 12 February, from your involvement in the preparation of the executive minute, and your receipt of the final version, that the DSS position at that point in time is reflected at that paragraph.
Yes.
Returning then to the chronology, after the brief B1539 was prepared and sent to Minister Payne on, I think, early 16 January 2015, you attended a meeting with Minister Payne at Sydney in the Commonwealth Parliamentary Offices on 20 January 2015.
Yes.
And Ms Golightly was also present at that meeting.
I don't recall.
And do you recall that B1539 was discussed with Minister Payne at that meeting?
Is there another document that references that meeting?
Oh, there are a number of them. I'm not sure if they are contained in this bundle before you.
Just to refresh my memory, if there's a document.
I don't think that there is a reference to the meeting in this bundle, no. Right. I take it without a reference to a document you don't recall the content of the discussion.
I haven't got the document in front of me. I can't remember all those documents, but if there is a document, I'm happy to look at it again.
Yes, I appreciate that. Without a document, is it the case that you can't recall much, if anything, of the meeting?
This was a meeting 8 years ago, so I cannot recall.
Thank you. Soon after the meeting with Minister Payne on 20 January, on the 22nd of January 2015, Minister Morrison was interviewed on the radio, and I'll take you to tab 7, where he described Exhibit 6875, where he spoke with the interviewer, Mr. Richardson, and said a number of things about his role in coming into the portfolio. And do you recall that Ms Golightly sent you an email in respect of that interview and a link to the full interview about 2 o'clock that day?
Yes.
The interview referred to a crackdown on welfare. Do you recall that language being used by Minister Morrison in that interview?
Yes.
And you can see a reference to the phrase, although it's not directly attributed to him, in the summary, that is the article from the Canberra Times Online, underneath the italicised words towards the below halfway. You'll see that the sentence commences, "It's a marked change of tone from his predecessor, Kevin Andrews, who always seemed happier handing out relationship counselling vouchers than cracking down on welfare recipients." See that?
I see that.
Yes.
Yes.
And the statement of the minister, I take it, was significant to you and Ms Golightly because it indicated the direction that Minister Morrison wanted to go in respect of his leadership of the portfolio generally.
Yes.
And it also provided some more context for the conversation you had with him on 30 December 2014 when he talked about an integrity package and questions of compliance.
No, I don't think it provided any more context.
All right. You'll recall that after that interview by Mr Morrison, I think B15/65 was prepared on or about the 23rd of January 2015, which was another brief to Minister Payne.
Can you tell me the tab of that, Mr Gregory?
It's not in this bundle. I didn't want to replicate areas that we'd covered earlier. I was only interested in the date.
I would need the document, Mr
Understood.
Gregory.
All right. And I'd ask that Exhibit 2493 and 2505 be prepared, placed on the screen. Ms Campbell, this is a statement of Ms Payne, prepared 9 December, that is, Senator Payne, prepared 9 December 2022. And I'll take you to page 2 and 3, which is paragraph 10D. It spans the page. And then we might come to the note itself. Ms Payne's statement identifies that on 2 February 2015, her calendar records a phone meeting with Ms Golightly at 10:30am and that her personal notebook refers to Secretary, MG, and the MG is a reference to Ms Golightly. The reference to Secretary was either a reference to you joining in the phone meeting or Ms Golightly acting as Secretary at the time. Can I pause there? It was the case that you had returned from leave and were working at this particular time. That is, you weren't on leave on 2 February 2015?
I'll need to check the records to determine whether that's the case.
Do you have access to those?
I do. It's in my statement,
Thank you.
my first statement. I was not, what's it, the date is the...
2nd of February 2015.
That was my first day returning from leave.
And the typed version of what appears in Senator Payne's notebook is set out in the balance of the paragraph there. You'll see a reference to cracking down. And a note, what can we do, W/O, having to legislate, and Senator Payne indicated that was without having to legislate. Do you recall that conversation with Senator Payne where there was a reference to the phrase cracking down?
No.
Viewing that now, and I can show you her handwritten note if you would like. Would you like that?
No, I saw it before.
Thank you. Do you accept that that was a reference to the language used by Minister Morrison in his interview on 22 January 2015?
If you're saying, is that the same language Mr Morrison used? Yes.
All right. Are you able to say whether it is a reference to the language he used or is likely to be a reference to the language he used?
No.
Right. At this time, were you aware of anybody else using that language in respect of the department's policy approach?
Yes.
Who else?
Some advocates who were opposed to compliance.
And in what context were they using that phrase?
Criticism.
Can you give more detail?
My recollection was that there were some advocates who criticised cracking down on recipients.
And is it your recollection that followed from Minister Morrison's interview 10 days earlier or so?
No.
That was a long-standing criticism?
Yes.
I understand. The question or the issue raised by the second part of Senator Payne's note is what can we do without having to legislate? Do you recall that at this time there was a large crossbench in the Senate?
Yes.
Which made the prospect of passing legislation in respect of matters dealt with by the Department of Social Services and the Department of Human Services possibly difficult to pass?
No.
All right.
You mentioned criticism coming from advocates of cracking down. What was the departmental attitude to that criticism and those advocates?
The department listened to ensure that it was operating fairly and to understand and to seek to understand to make sure there wasn't a failure in how we were operating.
All right.
Ms Campbell, can I take you to tab 8 in the volume, Exhibit 5212.
Exhibit 5212.
Yes, but it's behind tab 8 in your first volume.
Behind tab 8 I have 1599.
Yes, there is a different numbering system compared between the document number and the exhibit number. But it should be an email from Darren Kerr. Do you have that?
Yes, I have that document.
Tuesday, 3 February 2015. And it attaches a cover brief for Minister Morrison and an attachment which is a draft brief for Minister Morrison, which the Minister has asked to review. And the reference to Minister there is Minister Payne. In that last passage, the Minister who's asked to review the document, you can see.
Mr Greer, are you telling me that that's the Minister? I've never seen this document before.
Well, you can see that the email is sent to Ms Lees, Ms Payne's Chief of Staff.
Yes.
All right. And I'll take you then to the next exhibit, which is behind tab 9, the attachment, Exhibit 6876. You can see that it is an executive minute to the Minister for Human Services for action. And in the first paragraph of the draft, it says, "Thank you for the feedback you provided on 2 February 2015 on the proposed brief for Minister Morrison regarding current compliance processes and options for improvement." You see that?
Yes.
And if I take you to page 12 of 18 in that document, which is dot 1611, you'll see it commenced at the bottom of the previous page by reference to increased use of employment income matching. And if you look over on the dot points on the following page, sorry, could I have pages 11 and 12? Thank you. The dot points commencing analysis of pay-as-you-go, that is PAYG tax file from the ATO, you can see that.
Yes.
And you can see that there is a reference, the references to apportioning income have been removed in this draft brief as compared with brief B1539 from 15 January 2015.
So that's a question, Mr.
Yes,
Gregory?
you can see that the reference to apportioning, which was contained in B1539, no longer appears in the summary of the proposed measure by 3 February 2015.
Yes.
Right. And if I take you to tab 11, which is the executive minute I took you to earlier, Exhibit 2669, you'll see that even though the reference to apportioning income as the means of implementing the proposal was removed in this final version, page 10 of 17, otherwise, the nature of the proposal in terms of its analysis of PAYG tax file information for the 2010 to 2013 financial years remained the same.
In order to answer that question, I would need to go through line by line to determine whether there are any other changes to the document.
Right, I was going to deal with what had not changed. You will also note that the number of customers in respect of which interventions was said to be undertaken of 866,857 reflected no real change from the document as it was presented at least by the 3rd of February.
Which tab are we looking at for the 3rd of February, Mr. Gregory?
Tab 9, page 12 of 18. The first dot point at the top of page 12 of 18 on tab 9, which is exhibit 6876, refers to PAYG information for the 2010 to 2013 financial years and 866,857 customers. You can see that.
Yes.
Right. And the fourth dot point behind tab 9 refers to a 4-year measure to undertake those interventions.
The fourth dot point on page
12 of 18.
12 of 18, is that the fourth dot point down? Yep.
Yes.
Okay.
Yes, commencing the proposal will provide for a 4-year measure to undertake 866,857 interventions. I think what's on the screen might be the first dot.
I'm trying to compare the two documents, Mr. Gregory.
Yes, I see that. I'm just correcting what's on the screen, Ms Campbell. If those two passages could be taken down, and on the document on the left, the passage, the proposal will provide for a 4-year measure, if that paragraph could be called out. And if the fourth dot point on the document on the right could be called out.
Those paragraphs are the same.
Thank you. Thank you if those documents could be taken down. Ms Campbell, having reached the point by 12 February 2015 that the DSS position was that the measure required legislative change to introduce it, irrespective of the removal of the word apportioning from the description in the executive minute. Were you at all concerned about how that might be achieved if the Minister indicated that he wanted to pursue it?
No.
And why didn't you have any concern about that?
Passage of legislation was primarily a matter for ministers and the Department of Social Services. If the Minister thought the legislation could be passed, I was confident it could be passed.
But you understood that the 4-year plan was, if pursued as a budget measure in the upcoming budget, had to commence on 1 July 2015?
Yes.
Did you consider the possibility of legislation passing through the Senate between 12 February 2015 and 1 July 2015 was possible?
Yes.
And why did you take that view?
Because I had seen legislation pass in that time frame before.
Right.
Did it occur to you that this legislation would have to affect people's entitlement retrospectively? If averaging were to be applied, it would be going back to the first year, which I think is 2010 or 2011, and being applied to people's entitlement when it hadn't been originally.
I was not responsible for the passage of the legislation, and we had relied on DSS's advice about the legislation.
All right, no further concerns about affecting welfare recipients' entitlement retrospectively?
So I didn't have concern at that time, Commissioner.
Okay.
But you understood in a practical sense what the proposal envisaged was that retrospectively the question of whether someone's entitlement to an income support supplement would be determined according to income which was apportioned where there was no response or the person agreed with the PAYG information?
No,
Why didn't you understand that?
I was not responsible for the legislation at that time, and I relied on DSS to provide advice on the legislation.
I understand your position in respect of who was responsible for legislation. My question is about what was practically proposed in the various briefings, including in this executive minute, and that was that a person's entitlement to receive income support in the 2010 to 2013 financial years would be determined in 2015 or 2016 according to an averaging or apportioning of PAYG information over the period of time that they received the income supplement.
What was your question, Mr Gregory?
You understood that was the effect of the proposal.
I understood that the recipients would be asked to consider previous years' declarations of income and asked to update it. And that had been a process, not in this manner, that had gone on for many years of looking backwards at that.
And that in circumstances where they confirmed PAYG information was reported in an accurate total by their employer to the ATO, what then? Your understanding stopped at the point where someone was invited to confirm something, and I'm saying, well, what happens after that?
I don't understand your question, Mr Gregory.
You said, I understood that the recipients would be asked to consider previous year's declarations of income and asked to update it. Pausing there, what happened then? What was your understanding of what would happen then?
If it was updated to indicate that they had earned more than they had declared, then the entitlement would be recalculated.
And where they didn't update?
I didn't turn my mind to that.
Well, you plainly had turned your mind to that, Ms Campbell, because you read B1539, which talked about people being invited to confirm PAYG information if they wished to, and if they didn't, that their entitlement would be retrospectively calculated according to the average of the PAYG data.
You take me to the words where it says invited. I'm just looking for that.
Tab 6. Exhibit 1942. You'll see at page 14 of 30. Under potential priority new policy proposals, PAYG cleanup. You've read that?
So I can see where it says they'd be presented with.
Yes, and in paragraph C you can see that unless customers want to and are able to provide information that varies the outcome, the default position,
Default unless customers want to and are able to provide the information that varies the outcome.
Yes, It plainly conveys there's no requirement on the customer to engage. They're just provided with an opportunity to do so.
Yes.
And that was repeated in the executive minute, the concept of an invitation or request or an opportunity. And behind tab 11.
Tab 11, the word invitation.
Page 10 of 17, Exhibit 2669. See in the third dot point, it says customers are presented via their online account from information. They have an opportunity to update it prior to it being applied to their Centrelink record and the transfer of the obligation to them.
I see the word, the customer will be presented via their online account with the information obtained. The customer will have an opportunity to update. This puts the obligation on the customer.
You see in the fourth dot point the reference to the opportunity provided to a customer
I see
to
the
provide
word.
evidence.
Yes.
I suggest that when you read that, you understood that what would happen where a customer did not respond to the opportunity was that the ATO data would be applied by means of averaged application to determine entitlement.
Yes.
And that was different to the approach which was taken in respect of the entitlement when the person in fact applied for the benefit.
Yes.
So my question is whether you turned your mind then to the question of how legislative change could be implemented to allow that practical change in terms of the different means of assessing entitlement under this proposal.
No.
And you say that was because it was the responsibility of DSS.
Yes.
Did you take any step at all to satisfy yourself about how that might be done before 1 July 2015?
No.
These were your department's customers. Close to 1 million interventions were proposed. What was entailed was a retrospective change to the basis of entitlement. How could you not worry about that? How could you not wonder how this was to be done and whether it could be done?
Commissioner, at that time I relied on DSS to be responsible for the legislation with respect to the Social Security Act.
All right, but what about the practical effect on your department's customers of changing the basis of their entitlement retrospectively?
These were customers of both the Department of Social Services and the Department of Human Services.
Sure, they were yours too.
And the division of responsibility at that time was that DSS was responsible for the legislation.
Okay, but you were responsible for implementing policy and you were responsible for the impact on, we don't quite know the number of customers because 866,000 interventions doesn't necessarily equate to that many customers, but we can probably assume 500,000. Was it not a concern to you that it would have this kind of impact on a customer base of that size?
So many proposals had impacts on large number of recipients, and we worked with DSS on those, on the impacts to determine how best to implement the policy.
Right, and retrospective change of entitlement was not a concern?
These were matters that were discussed with DSS. I did not discuss them in detail with DSS at this time.
Okay, thank you.
Did you consider the question of fairness involved in changing the question of entitlement retrospectively?
No.
Did it cross your mind that it might be unfair to provide someone income supplement in a financial year earlier on the basis of income that they actually earned, derived or received during the relevant fortnight, and then retrospectively determined their entitlement based on averaged income?
My focus at that time was the opportunity for the recipient to engage with the system.
Do you mean that you considered the question of changing the entitlement retrospectively and thought that any unfairness was overcome by the opportunity provided by the proposal, or do you mean that the question of fairness didn't cross your mind?
I thought the opportunity for the recipient to engage would be a fair way of dealing with this.
And what, in the circumstances then where the recipient didn't engage, or did fairness cross your mind then?
At this time in 2015?
Yes, at the time the proposal was being developed by your department for Minister Morrison.
No.
At that time. At any other time did it cross your mind?
Yes.
And when was that?
2017, January.
What did you do about the question of fairness then in respect of people who didn't engage with the system?
We put final debt letters on hold while we changed the system to make it user-friendly for recipients to engage.
Did you still calculate debts based on this retrospective change of entitlement for people who did not engage?
So debt raising was put on hold from, I believe, January through to August of 2017.
And then it started again?
It started after the system had been improved, and Minister Tudge had noted that after a number of attempts to engage with the recipient, only then would be averaging used.
And so how was fairness taken into account then in the retrospective assessment of entitlement?
With attempts to contact the recipient.
Are you saying that your concern about the retrospective change to entitlement, that is, the fairness of that approach, was overcome by attempts to contact someone?
Yes.
And if they didn't contact, it served them right, did it?
No.
Well, how did it work? Do you accept that it is unfair to calculate somebody's entitlement on a different basis to that which actually applied when they received the benefit?
If the legislation did not allow, yes.
Well, you say legislation's somebody else's problem, but just the concept is a problem, isn't it? Isn't it intrinsically unfair?
So at that time, I thought it was legal. I now know that not to be the case.
All right. So you thought it was legal to change the basis on which entitlement was calculated from the original basis of entitlement. Therefore, if somebody didn't respond, it was all they could expect, essentially.
No.
I am just trying to understand what your position was. Did you think that averaging was just legal across the board?
No.
Well, then why was it legal for people who hadn't responded?
So my understanding at that time was that if it could be used as a last resort, and so that's why my focus was to ensure that it didn't need to be used by improving the ability for the recipient to engage with the system.
So we're going back to the Pulford advice, are we?
I'm going back to the advice from the Department of Social Services in January of 2017.
Okay.
And when you say, so my understanding at that time was if it could be used, the time you're referring to is in 2017 when the question of fairness crossed your mind.
Yes.
Right. Ms.
You didn't have to worry about fairness because you thought it was legal.
No.
Well, then, if you did worry about fairness, how did you worry about it for people who didn't respond?
Because are we talking about 2017, Commissioner?
Yes.
So we had suspended the debt raising at that time
And then you went right back to it in August.
until we'd had the opportunity to improve the system and to notify people and to ensure that recipients had received the correspondence.
Okay, and if they didn't respond, fairness wasn't an issue, or was it?
At that stage, I was relying on the advice from DSS that we could use averaging as a last resort.
Okay, so we're back to you thought it was legal, so fairness didn't matter.
I thought fairness had been achieved, procedural fairness, by ensuring that the recipient had received the correspondence and had received the correspondence.
Okay.
To skip forward to 1 July 2015, from the point in February we're talking about in 2015, your department commenced the PAYG manual compliance intervention process,
Yes,
and that involved averaging incomes in respect of persons who did not engage with that manual process.
I don't recall the details of that period. I can look at correspondence.
We were aware, at least by 1 July 2015, that DSS had not introduced legislation in respect of the lawfulness of averaging.
No,
You didn't know that, or you did know that?
no, I did not know that.
Thank you. You didn't keep up to date with what legislation was or wasn't introduced by DSS that might affect your department?
No.
Can I take you to tab 13, Ms Campbell, Exhibit 5221. You'll recall that Minister Morrison signed the executive minute on the 20th of February 2015, and that this email was sent from Parliamentary Services to persons within DHS on Monday 23 February 2015. See that?
Yes,
And one of the recipients includes the mailbox for your office.
yes,
And was this the first time, that is Monday 23 February 2015, that you became aware that Minister Morrison indicated he wished to pursue the PAYG measure, which was noted as requiring legislative change?
I don't recall.
Do you recall whether anyone contacted you between Friday 20 February 2015 and this day, Monday 23 February 2015, to give you advance notice that the Minister had signed it?
No,
Have you located any document in your preparation for evidence which indicates you had advance notice, that is prior to this email?
no.
Can I take you to tab 16, Exhibit 6880? This is an email from Ms Canning to you, Wednesday 25 February 2015, which sets out the timetable for the social services portfolio budget submission. Can you see that?
Yes,
It anticipates the exposure draft version is expected to be lodged on Tuesday 3 March. That was the following Tuesday, 6 days later.
yes,
And that the matter would proceed to consideration by the Expenditure Review Committee on Wednesday 18 March 2015.
yes,
Between the period from 25 February 2015, between the period from Monday 23 February 2015, when you received notice that Minister Morrison wished to pursue the PAYG clean-up measure, and Tuesday 3 March 2015, the date when the exposure draft was expected to be lodged, did you become aware of any legal advice which said legislative change was not required to implement the measure?
No.
Did you ask for it?
No.
Ms Campbell, can you turn to tab 18, exhibit 5223? It is an email on 25 February 2015, that is later that night, which talks about the progress of the savings options to be developed by DHS to be sent to Minister Payne's Chief of Staff, and the difficulty meeting the tight time frame. Do you accept that as a summary?
There's an email to that effect.
Can I take you to tab 19, exhibit 5224? Do you agree this is an email to the effect that persons within your department are working on the new policy proposal in respect of the matters contained in the executive minute to Minister Morrison, and hoping to have them in draft late on the Thursday afternoon?
Insofar as this is the email, it says that they're working on MPPs.
Yes. Sorry, I skipped over a passage in the previous email. If I could take you back to tab 18, exhibit 5223, you'll see at the centre of the page an email by you to, further down, yes. Thank you. An email by you to Ms Canning in your department, in which you say what appears there. Does your email to Ms Canning reflect your understanding of the discussions that were to occur between Minister Morrison's office and Minister Payne's office in respect of the measures addressed in the executive minute?
Yes.
What role, if any, did those discussions play, to your knowledge, in the progression of the measure to the ERC, the PAYG measure?
I don't know.
Did Senator Payne, Minister Morrison, or anyone from their offices convey to you that the ministers had agreed that the PAYG measure was to proceed to Cabinet irrespective of the question of the need for legislative change?
No.
Do you recall any discussion with your minister, Senator Payne, about the question of legislative change following the signing of the executive minute?
No.
What about Minister Morrison?
No.
What about within your department?
No.
Were you at all concerned about the topic of what could be achieved without legislative change, which came up in the meeting with Senator Payne on 2 February 2015?
No.
And is that because sole responsibility for the implementation of legislation needed to support the measure was the responsibility of the Department of Social Services?
No.
Well, why was it then that you were not concerned about the question of legislative change?
I was aware of other legislative change that had passed the Senate.
And how did that alleviate what was marked in the executive minute as a need for legislative change?
I don't understand your question.
I'm trying to understand your answer. You say you weren't concerned about the question of the need for legislative change.
No, because I had seen legislation be passed by the Senate.
In a short space of time, is that?
Yes.
Yes.
You didn't think the nature of this change might encounter some resistance, this PAYG change?
No.
What about those advocates you referred to earlier who adopted an approach over a period of time where they resisted attempts to crack down on welfare recipients? Did you think that they might oppose the change?
Yes.
Do you think that that might lead to some resistance in the crossbenchers or the opposition?
Yes.
And that might add a layer of difficulty to the passage of legislative change within that timeframe?
If you mean, could it have been difficult for the government? Yes, it could have been. But I had seen legislation passed, and I noted in that budget there was legislation with respect to the age pension. And it was passed.
And when was that passed?
I don't recall the exact date.
Was it in 2015?
It was introduced it was in the budget of 2015.
Yes, but when was the legislation introduced?
I don't know. I wasn't responsible for legislation.
Well, how did you know legislation had passed, or you saw legislation had passed in respect of the age pension?
It was a matter in the media.
That is, you found out about it in the media?
Yes.
And you don't recall when that was?
No.
You can't recall whether it was 2015?
I know it was passed before the 1st of January 2017, because that's when we implemented it.
That doesn't suggest it was a particularly quick process, though.
I don't recall.
Did you discuss the options that Minister Morrison wished to pursue, as he marked on the executive minute, with your counterpart, Mr Pratt, after you received it?
No.
Did you direct any of your deputy secretaries, particularly Ms Golightly, to engage with her counterpart, Ms Wilson?
I understood Ms Golightly was engaging with Ms Wilson.
But of her own volition?
It was her job to engage with Ms Wilson.
That is, she understood it was her responsibility and took that initiative?
Yes.
And did she keep you updated about that engagement?
Not that I recall.
Do you recall that it was Thursday, 26 February 2015? I'll take you to tab 20. Exhibit 6882. That your department informed the Department of Social Services that Minister Morrison had assigned the executive minute the previous Friday.
I have not seen this document before. I'm not copied in on this document.
I see that. Trying to nail down when you first became aware that the Department of Social Services was informed that Minister Morrison signed the DHS executive minute.
I don't know.
And are you unable to recall when it was that you knew that Ms Golightly was engaged with Ms Wilson in respect of those matters?
I don't recall.
Ms Campbell, can I take you to tab 24, exhibit 5225? The sequence is an email exchange between yourself and Ms Canning on 26 February 2015. Which refers to a final package of service delivery savings proposals prepared for Ms Lees, and you asked for a copy of the folder of those proposals at that time.
Yes.
And Ms Canning was the acting Chief Financial Officer, as her email footer indicates.
Yes.
And she had a relevant role in assessing costings for new policy proposals for the upcoming budget.
With respect to DHS expenses.
Yes. And it was in that context that she was involved in preparing the bundle of, or the package of savings proposals for the Minister for DHS.
Yes.
And does your email at the top indicate that you kept a close eye on the development of matters relevant to the upcoming budget consideration of
Yes.
DHS? Right. Can I take you to tab 25, Ms Campbell? Exhibit 6885. This is not an email to which you are a party, but it might assist your recollection. Sorry, a CTH.3095.0002.4675. Thank you. Ms Campbell, you can see that that's an email exchange between Ms Golightly and Ms Wilson on the evening of Thursday, 26 February 2015, which refers to a discussion the previous day, that is on Wednesday, 25 February 2015. The signed compliance brief from Minister Morrison and a reference to a meeting between Mr Withnell of your department and Paul and Murray, who are persons within DSS, for the following day, that is tomorrow, Friday, 27 February 2015. See that?
Yes.
The second last paragraph refers to Ms Golightly's understanding that Minister Payne's office was to liaise with Minister Morrison's office to set up a time to discuss these items, which appears to be a reference to the three items immediately above it. That is, those three which the Minister indicated he wished to discuss rather than pursue in the executive minute. Does this email assist you to recall when it was you discussed with Ms Golightly her interaction with Ms Wilson?
No.
It suggests that the earliest discussion according to this document, was Wednesday, 25 February 2015. Is that at least broadly consistent with your recollection?
No.
That is, you just can't say.
My recollection that there was an email to me from Ms Golightly earlier about her engagement with Ms Wilson. I think I saw it here in this pack. So under tab 5, there's an email on the 15th of January about the matter. If you're asking when it was decided by Mr Morrison to pursue, I don't have any recollection of the engagement between Ms Wilson and Ms Golightly after that time.
Right. Does the last paragraph assist you to recall whether it was Ms Golightly's responsibility to resolve any questions about what form the NPP would take in respect of the question of legislative change?
No, it was a joint responsibility with Ms Golightly and Ms Wilson.
I'd ask that Exhibit 5526 CTH.3023.0001.5380 be placed on the screen. And I'd ask that Ms Campbell be provided with a hard copy of this document. And if my learned friends, Mr Flynn and Ms Hogan-Doran, could each have copies as well.
Is my friend referring to the attachment to this email?
Yes.
Thank you.
Again, Ms Campbell, this is not an email to which you were a party, but it is between people in your department, Mr Ryman and Mr Britton, on Friday, 27 February 2015 in the afternoon. And you'll recall from the previous email I took you to, there was an indication from Ms Golightly to Ms Wilson that there was to be a meeting between people from DHS and DSS the following day, that is on Friday, 27 February 2015, just so you understand the chronology. And Mr Ryman asks Mr Britton, queries with him the attachment, the latest version of the Strengthening the Integrity of Welfare Payments NPP, bracket 6, and effectively asks Mr Britton to confirm that it's going in the right direction. The attachment is Exhibit 5527, and it's the hard copy in front of you.
The one we've been provided indicates it's 5522. But it must be 5527, thank you.
Thank you. You can see markup on the document, that is the attachment. And can I take you to page 3 of 6, Ms Campbell, .5383. You will see that there are various edits reflected there. And the second paragraph on that page is the one that I particularly wish to take you to. You can see the sentence this assessment will be based on the fortnightly attribution of the income advised by the ATO, equally distributed over the duration of employment for the period the customer was on payment, is replaced with the new approach will not change how income is assessed or overpayments calculated, but will enable the department to undertake a significant clean-up of potential incorrect payments for 866,857 customers for the 2010 to 13 financial years. You can see that?
Yes.
In your conversations with Ms Golightly about her interaction with Ms Wilson, did she communicate to you that she had reached agreement with Ms Wilson about the language for the NPP?
No.
Did she say anything about her discussions with Ms Wilson in respect of the NPP?
No.
That is, you are confident that her interactions were done of her own volition as part of her responsibilities?
Yes.
Right. And did you ask her at any point how those interactions were progressing in respect of this NPP, given the tight time frame?
No.
The significance of the measure in terms of the number of people that it might affect? It's described here as 866,000 customers. Did that prompt you to ask her how her interactions were going?
No.
Are you saying that you took no further interest in the drafting of the NPP following the receipt of Minister Morrison's signed minute?
Yes.
That is, you effectively relied on Ms Golightly entirely about the language to be used?
Yes.
As we come to it, you'll see that the language in the final version, indeed the exposure draft and following, contained the same phrase, the new approach will not change how income is assessed or overpayments are calculated. Did you ever ask Ms Golightly how that could be the case, given what you understood about averaging involving a retrospective change of entitlement?
No.
Why not?
Because I did not notice it at that time.
But over a series of documents you were involved in drafting or reviewing or receiving, it was very clear that the new approach did introduce changes which were set out in those documents.
I did not notice the change at that time.
Did you notice the change at any time?
In 2017, I asked why had the Commonwealth not introduced legislation when it had been initially envisaged that legislation would be required, and I was advised that in discussions between DHS and DSS thought that because the recipient would have the opportunity to engage, that there was no need for the legislation.
Did you ask, why do we keep saying that nothing's changed in the way income's calculated or, in the way income's assessed or debt's calculated?
I think, Commissioner, my view was that if the customer had been able to engaged and provided information, there was no change.
There was a massive change in what you were doing, which you understood at the time the NPP was developed, which was that you would now use averaging as a basis for assessing entitlement. How could you not see that as a change? You did see that as a change.
If the customer had not engaged, if the recipient had not engaged. If the recipient had engaged and provided other information, averaging would not be used. And my focus was on ensuring that the recipient was able to engage with the system.
Right, Mr. Gregory? Oh, actually, this might be a good point for morning tea, if that's a suitable time for you.
Thank you.
We'll come back at 25 to.
All rise. The Commission stands adjourned until 25 to 12. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. Ms Campbell, do you still have Exhibit 5527, the hard copy of the document in track changes in front of you?
Yes.
Can I take you to the very last page of the document? It contains a passage of the due diligence checklist, which includes the subheading legislation. And at 2.0 through to 2.2, various questions are asked and answered. The position at this time, Friday 27 February 2015, indicated not applicable next to 2.0. Has the Australian Government Solicitor assessed the constitutional and legislative authority risk? But at 2.2 there was an assertion that legislation was not required. You said earlier you weren't aware of any legal advice that the position had changed from the executive minute to the NPP considered by the ERC. Did anyone tell you that there had been an agreement with DSS about this?
No.
And did you ever ask?
No.
By delegating responsibility to Ms Golightly, that is for her to do her job and deal with DSS, do you accept that you are responsible as Secretary for whatever steps she took in respect of the question of legislative change?
If you mean by your question, was I responsible for Ms Golightly's actions? Yes.
Can I take you to tab 29, Exhibit 6887, and the attachment is at tab 30, Exhibit 6888. It is an email with the title Talking Points for Secretary's Meeting with the Minister. You are not a party to the email. It is exchanged between persons within DHS. It refers in the attachments to the 3rd of March 2015, although on the attachment itself, the date of 4 March 2015 appears as the relevant date of your meeting with Minister Payne. And can I take you then to the final page of the talking point, .5521, under the heading Business Integrity. The talking point provided by your department to you is set out in the first dot point here. Do you recall that the communication that you had with your minister was reliant upon what was said to you by Ms Golightly or prepared for you by Ms Golightly in talking points such as this?
No, I don't recall this until seeing it now.
Okay. That is, did you take any active step to satisfy yourself of what was happening beyond the receipt of talking points when you met with the minister?
I can't recall on this set of talking points. I've never seen it. I may have seen it in March of 2015, but today is the first time I've seen it again.
All right. Can I take you to tab 40? And tab 41, Exhibit 5230 and 6891. On Tuesday the 3rd of March, your office email address was copied into an email from Ms Canning to Senator Payne's Chief of Staff, which attached the draft NPP for the compliance package and sought approval for the provision of the information to the Department of Social Services. You see that?
Yes.
Does that confirm that before the draft, that is, before the NPP drafted by your department in respect of the PAYG proposal and others, could be forwarded to the Department of Social Services, it required your minister's clearance or approval?
Yes.
Right. And to your recollection, was Senator Payne closely involved in the review of the draft NPP?
I cannot recall.
And again, on the last page of the attachment, as it was provided by your department to your minister, under the due diligence checklist, it was said that legislation was not required for the measures contained in the draft.
That's what this document says.
Yes. Right. You don't have any direct or indirect knowledge about the basis on which that position was adopted?
No.
And you didn't notice on 3 March, I take it, that the position set out in earlier briefings to the Minister, that is Minister Payne and Minister Morrison, about the need for legislative change was removed, and the positive assertion that there would be no change to how income is assessed or overpayments are calculated was the new position.
It's not clear to me that I saw this email on the 3rd of March.
In terms of costing, can I take you to tab 42, exhibit 5233, and tab 43, exhibit 5324. Still on 3 March 2015, Ms Canning sent emails to the email address. Sorry, the second document I'm after is cth.400.00399.00275234. Sorry, I read that exhibit number out incorrectly. The process which is revealed in the first document was Ms Canning from your department forwarding to the Minister's office a message about the costing work which was undertaken by your department that day, and that insofar as the costing numbers in the NPPs were being worked on, the process required the involvement or agreement of the Department of Finance.
That's what this document says.
All right. And you, I take it, were closely involved in the costing of the measure insofar as expenditure by DHS necessary to implement the measure was involved?
It's not clear at this point that there were costings.
No, but as Secretary, I'm suggesting to you that you were closely involved in the costings of the measure insofar as it related to expenditure required by DHS to implement the measure.
Yes, when the document was sent to me to clear the costing.
Yes. That document, and we'll come to it, also contained the same statement that there'd been no change to the way income was assessed or debts were calculated. Did you notice at that time the change in position from the earlier minutes?
No.
Are you able to say from these two emails on 3 March 2015 from Ms Kenning of your office to Senator Payne's Chief of Staff that Senator Payne was closely involved in both the costing aspect and the settling of the terms of the draft NPP?
It is not clear to me that there's any mention of Minister Payne in these documents. It is not clear to me whether I saw these documents.
And are you saying that you don't have any independent recollection of Senator Payne's close involvement in either costings or drafting of the MPP?
If you're asking me, did I have any independent knowledge? No, I don't.
Does it also follow from your earlier evidence that you didn't seek any assurance in respect of the basis on which legislative change was no longer required, that you did not provide any assurance to Senator Payne that no change in legislation was required to implement the measure?
So if you're asking, did I provide any assurance to Minister Payne on legislation? No.
To your knowledge, did anyone in your department provide any assurance to Minister Payne that there was no longer a need for legislative change?
Not to my knowledge.
And to your knowledge, Senator Payne never asked you about the question?
No.
And to your knowledge, Senator Payne never asked anyone in your department about the question?
Not to my knowledge.
Can I take you to tab 53, Exhibit 2259. We move to Wednesday, 4 March 2015, Ms Campbell. You are not a party to this email, but it refers to both the time frame for the portfolio submission for coordination comments and to costings. It also refers in the last paragraph to the need to obtain the Australian Government Solicitor's opinion regarding constitutional risk. Do you see that?
Yes.
Right. To your recollection, does that email reflect the continued expectation of the tight timeframes which you saw earlier?
The first time I've seen this email now. Yes, the tight timeframes remain.
Thank you. I take you to tab 56, Ms Campbell, Exhibit 2263. This is an email exchange within persons or between persons within your department referring to the advice of the Australian Government Solicitor. Were you ever informed of what is set out here, that the advice from the Australian Government Solicitor was related to spending activities involved in the new policy proposal.
No.
It was limited to effectively the costings that you were concerned with, the expenditure of the implementation of the proposal.
What was your question, Mr Gregory?
Were you ever informed that the advice of the Australian Government solicitor was confined to the expenditure involved in implementing the proposal?
I knew that as part of the MPP template.
That is, you understood that the role played by the Australian Government solicitor reflected in the NPP template was confined to the constitutional or legislative authority for the expenditure required by the measure.
Yes.
And you understood that in distinction to what you've said earlier about the legislative basis for the recovery of alleged debts.
Yes.
Ms Campbell, can you turn to tab 58, exhibit 6899? This is an email between various persons within your department on Saturday, 7 March 2015, in respect of the costings for the measure. Which were not insignificant, would you agree?
If you're saying that 285 million over 5 years is not insignificant, yes, noting that the budget for the Department of Human Services was $5 billion a year, so $20 billion over the same period.
And you understood, of course, your obligations, or the obligation imposed on you by the Public Governance, Performance and Accountability Act in respect of ensuring that expenditure undertaken by your department was done lawfully?
Yes.
And following at least 7 March 2015, there was unresolved the question of the approved expenditure for your department to carry out the measure remained unresolved until almost the announcement of the budget on 12 May.
Yes.
And over that period of time, these projected numbers altered somewhat, but the approved expenditure still was in at more than $200 million.
Yes.
What steps did you take, given your understanding of the obligation imposed on you by the Public Governance, Performance and Accountability Act about the lawfulness of the expenditure, to satisfy yourself that the scheme was lawful?
I don't recall any steps other than relying on Ms Golightly's recommendations on the new policy proposal.
And what do you refer to then?
That Ms Golightly was working up the new policy proposal, and I did not ask her whether it was a lawful expenditure under the PGPA Act.
Right. But you could have taken other steps. You could have obtained a legal advice in respect of the lawfulness of the projected expenditure of more than $200 million.
Yes.
Why didn't you do that?
There were some 58 measures at that time. I didn't ask for a legal opinion on the lawfulness of any of those 58 measures.
To your knowledge, which of those measures had previously indicated they required legislative change?
I cannot now recall. I can get a copy of the documents of the new policy proposals and go through them if necessary.
You see, it's one thing to say, well, it was DSS responsibility to introduce legislation in respect of the measure, but that does not detract from your personal responsibility under the PGPA Act to satisfy yourself that the measure was lawful.
What was your question, Mr Gregory?
You gave evidence earlier that it was DSS responsibility to introduce legislative change to enable the measure to proceed. My suggestion to you is that your position in that regard does not detract from the obligation on you to ensure that expenditure in respect of the measure was undertaken lawfully. Do you agree?
If you're saying that I should have sought independent legal advice to ensure that I was operating under the PGPA Act, I accept that now. At that time, I had relied upon DSS to ensure their advice that the program we're implementing was lawful.
But you didn't receive any advice from DSS, I think you said.
Not at that time, no, but I relied on Ms Golightly.
But Ms Golightly didn't provide you any assurance that the measure did not require legislative change.
At this time, we didn't seek legal advice on every decision around NPPs.
Yes, but to be clear, Ms Golightly didn't assure you that legislative change was not required for the measure, did she?
Not that I recall.
The costing document to which you referred earlier is behind tab 61, exhibit 1952. Ms Armour sought your approval or clearance, to use the word in the email, for the costings that had been developed by your department in respect of the measure. You see that?
That's what the email says.
And the attachment which you were briefed on Monday, 9 March 2015 is behind tab 62, exhibit 2024. Can I take you to the second page of the document, dot 4298. You'll see a marked change in blue at the bottom of the page, which refers to the employment income matching measure and says that the approach will not change how income is assessed or overpayments are calculated. Did it occur to you to ask, after reading that in the context of approving costings for the measure, how that could be?
No.
I take you to page ending dot 4304 in the top right corner. It is a page which refers to the basis on which various aspects of the work required by the department to undertake the measure are identified, and they include a reference to workload volumes. There are dot points which include inquiries, reviews and appeals, and there is also a passage in respect of average staffing levels. See that?
Yes.
And you can see that the average staffing level required an additional, at this point, 853 staff in the 2015-2016 year, which reduced to 288 in 2018 and 2019, according to what was developed by your department at this point. And the explanation was because the manual process in the 15-16 financial year would be replaced over time with the automated solution. And was that your understanding of how the measure would operate?
Yes.
Necessarily for the measure to operate in that way, customers had to engage in an online process, didn't they?
Yes.
Right. And did you come to learn after the pilot was conducted in 2015, after the announcement of the budget measure, that a large proportion of persons did not engage in an online process?
No.
Can you go to tab 64, please? Exhibit 6903. Confirm that later that evening you confirmed or approved the costings which had been forwarded to you in that document.
Yes.
When I asked you before whether it occurred to you to ask a question about how the position had changed in respect of the costing document, I take it you read it.
I read the top lines of it because I was focused on the financial impact. I cannot recall whether I read every line of it. I most certainly would have read the table CTH.3004.001.4298, which identified the DHS costs.
Ms. Campbell, can I take you to tab 70? Exhibit 5253. On 10 March 2015, that is the day after you approved the costings, you were copied into an email from Ms. Canning to Minister Payne's Chief of Staff with an update on the scheduling of the Department of Social Services portfolio budget submission. You accept that?
I see that.
And there is a reference there to Minister Payne's clearance towards the end of the email on the revised NPPs. Was it your understanding at the time that Minister Payne was closely involved in the approval of successive drafts through the exposure and coordination draft process?
I don't know. The email was to her Chief of Staff.
All right. You see that someone in your office asks her Chief of Staff for the Minister's clearance in respect of that?
So someone in the department, yes, Ms. Canning, but Ms. Canning wasn't in my office, she was in the department. I see what that email says. I don't know what happened in Senator Payne's office.
Did you not know at the time that Senator Payne was closely involved in the clearance of the NPPs?
I don't recall.
I take you to tab 72, exhibit 5254. I provided a further update from Ms. Canning that night about the portfolio budget submission schedule. That is that the revised portfolio budget submission was being sent to Minister Morrison on Thursday, which was 12 March 2015. You can see that.
Yes.
And you responded good outcome in terms of the increased amount of time for DHS to have the NPPs amended to reflect exposure draft comments and cleared by Minister Payne.
Yes.
I take you to tab 76, Exhibit 6911. And you'll see a reference there to discussions between your office and the Department of Prime Minister and Cabinet about the integrity proposal. And there was a reference to a suggestion that DHS make it very clear up front that the measure paid for itself and is a net saving each year. Do you recall being informed about your department resolving questions about the measure with the Department of Prime Minister and Cabinet?
No.
What about the Department of Finance, engagement with the Department of Finance?
No.
Are you familiar with the concept of a risk assessment potential tool in respect of new policy proposals?
Yes.
Can you turn to tab 78 and 79, Exhibits 6913 and 6914? The email of 11 March 2015, Exhibit 6913, CTH.2004.002.677, is between persons within your department in respect of the risk assessment potential tool and indicates that the residual risk rating is low and that, according to the instructions on the document, that could be copied and pasted into the implementation arrangements section of the NPP, and that because the level of risk before mitigation was low, the tool did not need to be distributed further. You see that?
Yes.
And is that consistent with your understanding of the way in which this tool is used?
If you're asking me, is that my understanding of how the tool is used? That's my understanding, but I haven't looked. This is the first time I'm seeing these documents.
Did you make any inquiries about the question of the application of the risk assessment potential tool to this NPP?
No.
And that is whether information in the document was filled out in a way which accurately reflected the NPP?
No.
You relied on people within your department to undertake that and insert it into the NPP?
Yes.
And I take it then as Secretary you accept that you're responsible for those actions?
I am. Just to clarify that, so as this, I am not the Secretary anymore. As the Secretary at that time, I was responsible for staff within the department, the actions of staff within the department, but I did not see these documents at that time.
And if I take you to tab 81, just wanted to clarify your evidence earlier. Exhibit 6916 you are the recipient of an email from Ms Canning on 11 March 2015, which records towards the bottom of the page that an updated pack of the revised NPPs will be provided to the Minister and the Secretary that afternoon, and that there were only 4 DHS NPPs left at that time.
Yes, that's what's written on this piece of paper.
And that reflected the fact that DHS had developed 4 NPPs for the DHS portfolio budget submission in the upcoming budget.
So it says, so we only have 4 DHS MPPs left.
Yes, because you started off with 6.
Yes, but that doesn't mean that they weren't the only ones that DHS was involved in. They were the ones DHS was drafting.
That's right. And so when it comes to the question of how many NPPs DHS was involved in, you know that the ones that DHS was responsible for included this particular one and 3 others.
The ones that DHS was drafting,
Yes.
when you say responsible for drafting
Yes.
rather than responsible for implementing.
Well, you were also responsible for implementing what you had drafted, that is, what your department had drafted in respect of the Strengthening the Integrity of Welfare Payments measure.
Yes?
And I'm suggesting the fact that you had 4, your department had 4 proposals which it was responsible for drafting, as well as implementing, meant that you would have paid close attention to the content of the new policy proposal.
I paid close attention to the entire 50 measures that we were implementing.
And I take it then that it was not lost on you that there had been a change in position in respect of the need for legislative change to implement the measure.
I had earlier provided evidence that I had not noticed that that change had occurred.
Do you maintain that, despite your evidence, that you paid close attention to each one of these?
I do.
I take you to tab 83, exhibit 5257. This is an email from Ms Canning to you and your response on 11 March 2015, where you were informed that the revised DHS MPPs were signed off by Minister Payne and are now with DSS. You see that?
Yes.
And a hard copy was provided to your office that afternoon at about 6 p.m.
I see those words.
And do you maintain that you, despite your close attention, did not notice the change in position in respect of the need of legislative change on this date either?
If you're asking me, had I noticed the change? I had not noticed the change.
Can I take you to tab 87? Exhibit 6919. The date is 12 March 2015 in the email at the bottom of the page. Ms Canning wrote to Ms Golightly, and referred to briefing notes on each proposal to support yourself and Minister Payne in preparing for the consideration of the Social Services Portfolio Budget submission by the Expenditure Review Committee. Can you see that?
I can see that email, yes.
I take it that you were aware by 12 March 2015 of the possibility that you would attend the Expenditure Review Committee in relation to these proposals.
I don't know that I don't recall that, but I don't think I was copied on this email. And I've been unable to access my diaries.
Why is that?
It's a matter for the Commonwealth. They have been unable to provide my diaries to me.
What sort of diaries did you maintain?
Electronic diaries.
Did you know in advance of the expenditure review considering the DSS portfolio budget submission on 25 March 2015 that you would be attending?
I expect I did.
You say you can't recall it.
Okay. I thought your question was, did I know in advance that I'd be attending?
Yes, and you said you expect you did.
Well then, because I am unable to access my diary, I assume it was placed in my diary and I would have been aware it was in my diary.
I take you to tab 97, exhibit 6929. On Tuesday, 17 March 2015, you were copied into exposure draft comments in respect of the Department of Social Services portfolio budget submission.
Yes.
Which included the PAYG NPP.
Yes.
Right. And did you notice on that date that there had been a change to the question of the need for legislation?
No, and I'm not sure how I would have, because these were exposure draft comments made by other agencies. And my recollection of the attachment to this email was that there were few comments made with respect to that measure.
I take you to tab 105, exhibit 6934. You can see that this is a forward of a meeting invite for yourself, Ms Lees and Ms Golightly and two others in respect of an expenditure review committee briefing on Wednesday, 18 March 2015.
Yes.
Do you have any recollection of attending that briefing?
No.
Did you have any record that you made in the briefing?
Not that I have been able to find, but I assume with this invite was something that's been able to be obtained.
Undoubtedly, if you attended an expenditure review committee briefing, you would have closely reviewed the portfolio budget submission, particularly the matters which related to your department.
In the time available, I would have, but I note that there are other participants attending as well who would have been able to brief the Minister as well on specific measures.
Can I take you to tab 106? Exhibit 6935. The document reflects a meeting organised by Minister Payne for a briefing for the Expenditure Review Committee on Wednesday, 25 March at 8:30 in the morning?
Yes.
Do you recall attending a briefing in respect of the Expenditure Review Committee on that day?
I don't recall the meeting, but I note the diary entry has been provided.
Can I take you to the second volume, Ms Campbell? Tab 122, Exhibit 5267. There is an email
That's what the email says, yes.
It reflects what you would expect if you were anticipating an attendance at the Expenditure Review Committee,
Yes.
and that you were preparing in advance for that event.
Yes.
Part of your preparation is also reflected in behind tab 126, Exhibit 6947. In respect of various aspects of the costing, that is the expenditure involved in the measures,
I'm sorry, Mr Gregory, your question?
You were engaging on the afternoon of 25 March 2015 in an email exchange with Ms Golightly in respect of the expenditure or costings so far as DHS was concerned in respect of the measure.
Yes.
That is, the Department of Finance position remained not agreed between it and your department.
The Department of Finance position was about ASL and they didn't want to agree, staff?
Yes.
Yes.
And as part of preparation for the ERC, you received a copy of the DSS portfolio budget submission.
No, I didn't get the entire submission. I would have got extracts that were relevant to the Department of Human Services.
All right. And you accept, of course, that you attended the Expenditure Review Committee meeting which considered the DSS portfolio budget submission on the afternoon of Wednesday, 25 March 2015.
I accept on the list it says I attended. It's not clear whether I was in the meeting for when particular items were discussed. The way that those meetings worked, officials were not always called in.
Can I take you to tab 129? Exhibit 5694. You can see it is a copy of the Expenditure Review Committee second revised business list.
Yes?
And at point 5A, it refers to the 2015-16 budget social services portfolio budget submission, where Mr Morrison, Senator Payne and Senator Fifield are referred to.
Yes?
And if you turn to tab 130, exhibit 5081, you'll see that the Expenditure Review Committee attendance record for that date contains your name and the heading departmental official in the bottom right corner in respect of item 5A only.
Yes?
Which confirms that you attended the ERC consideration of the DSS portfolio budget submission.
If you're saying that I attended for the entire item, I am unclear of whether I did. This document says I attended at some point for that item, but it's not clear whether I was there for the entire discussion or if the item was in fact discussed.
What it says was you attended in respect of item 5A, which was the DSS portfolio budget submission together with the respective ministers.
That's what the document says, but the practice was not always that officials were in attendance for the entire item or even were there when the item was discussed.
Are you suggesting that you were not present when the NPP was discussed?
No, I'm not suggesting that, but I cannot say that I was.
You simply don't recall how long you were there?
I do not recall how long I was there.
We go to the NPP. It's behind tab 131. Exhibit 2022. This formed part of your brief for the ERC.
Mr Gregory, can I confirm you're saying, was that a question or a statement?
It is a question. I'm asking you to confirm that you received this as part of your brief for the ERC.
I can't confirm that. I've asked for that document to be found by the Department of Services Australia and they've been unable to provide that to me.
I take you to page 22 of 364. You can see The reference to more than 800,000 individuals who have, over a 3-year period between 2010 and 2013, likely failed to declare their income correctly in the second paragraph at the top.
Yes, I can see that paragraph.
And you can see what is described as the introduction of an online approach below the redacted portion at the centre of the page, through to the end of the page.
Yes.
And the measure refers to discrepancies identified based on an analysis of the PAYG file obtained from the ATO, which was presented to the customer. You see that?
Yes.
And the assertion in this second sub-dot point that the new approach will not change how income is assessed or overpayments are calculated. You see that?
Yes.
But it otherwise refers to the same 866,857 customers, which was addressed in the executive minute to Minister Morrison for the same period of the financial years from 2010 to 2013.
Your question, Mr. Gregory? I'm sorry, I missed the start of your question.
The NPP, as it was presented to the ERC, refers to the same 866,857 customers for the same period, 2010 to 2013, as was referred to in the executive minute to Minister Morrison.
Yes.
And you knew at the time that that level of intervention and debt recovery could not occur without the online process being developed over that period of 4 years.
Yes.
And you knew that it could not be achieved without the averaging of income.
The averaging of income was a component of it.
Yes.
The reason for the online system was to build an engagement platform with the recipients.
It was also to reduce the involvement of the average staffing level in compliance and debt recovery over the 4 years.
There was no reduction in staffing level. There was an increase in staffing level.
It was intended to involve a reduction in staffing level over the 4 years because of the introduction of the online measure.
No.
There was no aspect of the online compliance scheme that it would reduce the need for staff intervention and hence the numbers of staff, are you saying?
No, Commissioner, there was actually an increase in staffing in order to facilitate the additional reviews.
Well, we know what happened when it turned out people didn't go online, but when this proposal was presented, are you saying it was no part of it that it would reduce the need for numbers of compliance staff?
The proposal was to increase the number of reviews. There was no reduction in staff number envisaged, and that's why there was so much tension with the finance department, because it required additional staff.
Okay.
But you understood the intention of the measure was to reduce the staffing level in terms of the ratio between staffing level and the previously undertaken compliance process.
If I understand your question, it's hypothetical if we had continued the other process.
The 20,000 a year.
So there was no reduction in the 20,000 a year. There was no reduction in the staff numbers.
Yes, we may be at cross purposes. The increase in staffing numbers permitted the department to undertake many more than 20,000 debt reviews per year.
Yes.
And the proportion of increased staff, as I understand your answer, reflected a much greater number of interventions than was able to be undertaken in the manual process prior to the PAYG measure.
Yes.
That is, the staff involvement per intervention or review was significantly decreased.
Yes.
And that followed from the online nature of the measure.
Yes.
So that although there was an increase of staff sought, it was an exponential increase in the number of debt reviews that were able to be undertaken, at least as it was proposed.
There was an increase. I'm not sure I would call it exponential.
Well, at least it was described as moving from 20,000 a year to 20,000 a week in late 2016. Would you describe that as would you describe that as exponential?
No.
Wasn't the proposal for an extra 853 for the manual intervention phase?
Yes,
Okay, but
there was more staff required after that first manual phase, is my recollection. There's an ASL table in the MPP which is redacted. No, it's not. So page 20 of 364, after tab 131, shows the increase in ASL over the period.
That is, it reduced over the period?
It increased. The plus indicates an increase.
Yes, 939 were projected to be required in the first year.
570 in the second year.
That reflects a reduction from 939.
550 is less than 939, but 550 is more than zero.
Yes, I understand. You're not saying that the 550 is added to the 939.
So if we assume there was no ASL at the start for this measure, there was 939 additional from 14-15 in 15-16, 570 in 16-17, 550 in 17-18, and 329.6 in 18-19.
how do we read the bottom line then?
That's the overall staffing in the department, and that was decreasing for a number of other reasons,
Okay.
like probably another 300 measures. So this measure was not about decreasing staff.
It was about decreasing staff involvement in compliance interventions.
It was increasing staff involvement in interventions.
Well, on the large scale, maybe, but in terms of any given intervention, staff involvement was supposed to be reduced, wasn't it? Wasn't that the
Yes.
whole idea?
Yes.
So as Mr Gregory said, if you're going from 20,000 a year to 20,000 a week, proportionally you had a dramatic decrease in staff involvement.
Proportionally, yes.
Okay.
Returning then to the assertion in the NPP that the new approach will not change how income is assessed or overpayments are calculated, at page 22 of 364, you would accept that that is not an accurate statement of the new approach.
Yes.
And in fact, it factually misrepresented the nature of the changes under the new approach.
It was only correct if the recipient engaged.
Well, averaging, as you've indicated, was the position if people did not engage,
Yes.
and where people engaged and confirmed the accuracy of the PAYG report provided by their employer to the department, averaging was used there also.
No.
You said earlier that the approach retrospectively changed the basis of entitlement to the income support supplement.
If averaging was used without engagement.
And the engagement changes occurred from 1 July 2015. Sorry, the averaging change was took place from 1 July 2015.
The averaging to raise the initial letter to ask the recipient to engage. And my understanding is from the 1st of July 15 to the 1st of July 16, that required a manual engagement process with the recipient to walk them through that activity.
Well, this represents a description of the 4-year measure, doesn't it?
Yes.
And treats all 4 years as the same, in the suggestion that there would be no change to how income is assessed or overpayments were calculated.
Yes.
And with the manual engagement, if the customer didn't respond, averaging was used.
I don't recall, Commissioner, I don't have that to hand. I haven't looked at that for some time.
And then, in relation to one of your earlier responses to Mr Gregory, with the online system, if you got online, looked at the details that were provided, which was the employer's report of your income from a date to a date, and said, yes, that reflects my income for the financial year, then you would devolve to averaging automatically.
There were shortfalls in the online system. In that first period, it was rolled out, and that was what was changed from 1 July 2017 to make it clearer what was being used. And then the option was provided for recipients to be reviewed and to go back and look at whether that had occurred.
All right.
And Cabinet was not informed about the change involving the transfer of the onus from Centrelink to investigate whether it had existed with employers.
Yes.
The way in which my friend has formulated that question,
Look, my ruling was that what was known of the NPP, what was made known of the NPP to Cabinet should be produced, and that's in the form of this document. So this document, I suppose
if my friend formulated the question in terms of the document as opposed to Cabinet's information at large.
that somebody might have popped up in Cabinet and said something contrary to the document.
Yes, I didn't mean to make it broadly in terms of what was said orally at the Cabinet. And by this document, Cabinet was not informed of the change in the transfer of the onus.
No.
And by this document, Cabinet was not informed of the change to the treatment of ATO data by its use of averaging.
No.
And as you previously said, those are two substantial changes in the proposal.
Yes.
And you must agree with me then that this document, in its assertion that the new approach would not change how income is assessed or overpayments are calculated, misled Cabinet to that extent.
To the extent recipients did not engage, yes.
Well, to the extent that it didn't identify that the change involved a change to the assessment of the calculation of income by reference to averaging, you would agree it was misleading to that extent?
I agree it was misleading to the extent that if the recipient did not engage, yes.
But it was a change even if the recipient did engage, because previously a departmental officer would have gone through the file and contacted employers to determine income, to assess income, and that was not going to happen anymore. So even for the person who engaged, it was a change in how income was determined.
If the recipient had engaged, they could have provided that information and that would have been taken into consideration.
Yes, but now you were requiring them to provide it and making no other inquiry. So there was no recourse to employers' records as there had been in the past.
My recollection is that we did change that in 2017 when we had,
But that's avoiding the question, which is that there was a change as at 2015, even for recipients who engaged, as to how you would determine what their income had been.
yes,
Okay.
And to that extent then, this document was misleading in its assertion things had not changed.
yes,
When you prepared for the Expenditure Review Committee and you were provided with this aspect of the DSS portfolio budget submission, did you notice the assertion then that was inconsistent with what had been provided in previous briefings to ministers?
no,
Is it your evidence that a document which was capable of misleading a subcommittee of Cabinet went unnoticed by you despite your earlier involvement in those briefings?
yes.
And is that because you didn't pay close attention to the document?
I cannot recall why I didn't notice it.
And yet you were closely involved in the costings of the measure based on this description.
Yes,
Are you sure that there was no pressure placed on you by ministers to support, to attend the ERC where there remained a question about the need for legislative change?
if you're asking me, was there pressure placed on me to attend the ERC and say that no legislation was required? No.
And you're saying that the drafting of this document, to the extent that it is misleading, was not the result of any pressure placed on you by ministers to progress the measure to the ERC?
No. There was no pressure.
And so do you then take responsibility for the drafting of this document, which had its origins in your department?
As the Secretary, I was responsible for what happened within the department. I did not notice the change in the drafting.
And on the basis of this NPP, your department was allocated more than $200 million in funding as part of this budget measure over 4 years.
Yes,
And you continued with your involvement in the negotiation of costings following your attendance at the ERC,
yes,
which included being copied into or involved in drafting letters between various ministers.
yes.
Was it inadvertence then on your part that this document, capable of misleading the Cabinet, came through so many drafts before it was considered?
So many. I'm just trying to understand your question.
Commissioner, that question was a little confusing in the sense of it wasn't clear what the inadvertence was referring to, but it may just be the way it was put.
Yep. Try again.
Was it your inadvertence then that the document arrived in this form before, for the consideration of the ERC?
Yes,
It's a significant oversight on your part, isn't it?
yes,
Another view of the way in which it arrived does not involve inadvertence. It involves a considered decision by your department to change language without changing substance so as to avoid the need to identify legislative change was required to introduce the measure. What do you say to that?
I do not agree with that.
And why do you not agree with that?
Because we had clearly said that it required legislation in the briefing to Mr Morrison in February. If we'd been trying to avoid legislation, there would have been no need for us to say that at that time.
That is, the misleading could have happened prior to that point.
If as you are putting to me, that the department sought to mislead, there would have been if that was the case, and I have never been in a department that has sought to mislead the government, and nor have I ever been involved in an operation that seeks to mislead the government. But if that was the case, there would have been no need to have put it in the briefing to Morrison in February.
What about the possibility that after Minister Morrison signed the executive minute on Friday, 20 February 2015, indicating that he wished to pursue the measure, which was identified as requiring legislative change, there was realistically no possibility that could occur if it remained the position that legislative change was required prior to implementation on 1 July 2015? That is, you were put in an impossible position by that point.
Well, it wasn't our position to get the legislation through, so I wouldn't have considered that an impossible position for DHS.
But as you've seen, by Friday, 27 February 2015, officers of your department have reworded this critical paragraph and added a note that legislation is not required.
And until today, I was unaware of that email.
Yes, but as you say, that was because you didn't ask and you didn't look closely at the measure at any point. Nonetheless, the fact remains these words originated within your department, and the first suggestion that legislation was not required came from your department in the absence of any contrary legal advice.
So I have seen that today.
Yes?
And I don't know why it occurred.
You can't explain what prompted that rephrasing of the critical paragraph, which was capable of misleading the Cabinet.
The only other evidence I have seen is when there's been emails from the Department of Social Services in January of 2017 that said once they saw more details of what was proposed by DHS, they came to the view that legislation was not required. And that was in January 2017 from Ms Halbert.
Ms Wilson's evidence was that about the 27th of February she met with Ms Golightly, and it was on Ms Golightly's assurance that there would be no change in the way that income was assessed or overpayments calculated, and that would be in the NPP, that DSS then desisted from any statement that legislation was required. In other words, her evidence is that she was misled by Ms Golightly's promise that there would be no change and that would be said.
I wasn't at that meeting. I don't know what went on between Ms Wilson and Ms Golightly.
Well, there's a strong possibility at least that it was communicated at that meeting that the NPP would say that no change was required. And if Ms Golightly made such a representation, it would be extraordinary for that to have occurred without your knowledge and concurrence. Do you agree with that?
No, I do not agree with that.
You think she would have done something like that without?
I don't know what happened, Commissioner, between those two officers. And I have no recollection of discussing this with Ms Golightly. But I don't accept that Ms. Golightly went with my permission to do that.
Okay, and do you think it possible that she would have done such a thing without your knowledge or consent?
No, I don't.
All right.
I don't know that she would have done that.
Don't know or don't think she would?
I don't think she would have done that. I think she would have worked with Ms. Wilson on the proposal within the requirements of the law.
Well, somebody clearly didn't, Ms. Campbell, and the question is where that came in. But anyway,
Ms. Campbell, can you take the third volume of documents?
can you take that like that?
And turn to tab 289. It is Exhibit 7016. It is a two-page document headed "A Message from the Secretary Online Compliance System." You see that?
Yes.
And this was a message which you revised and approved to be sent on the 25th of January 2017 to staff at your department. That's correct?
I approved. I can't see any evidence of revising.
All right, I'll take you to tab 290 and 291. At tab 290, which is Exhibit 7017, and tab 291, which is Exhibit 7018, you'll see a document with revisions and an email which refers to your approval of a draft which has been marked up.
The writing behind tab 291 on the document is not mine.
And do you dispute that you approved the staff message as reflected in the email Wednesday 25 January 2017?
No.
All right. And if I take you back then to Exhibit 7016 behind tab 289, you will see on the second page of the document the paragraph which says how we match records with the Australian Taxation Office. ATO is not a new process. We have been doing it successfully for many years. There have also been no changes to how we assess income or calculate and recover debts. You can see that?
Yes.
That was your message to your staff on that day. That's correct?
Yes.
Those are effectively then your words.
Yes.
And you perpetuate the same misleading position that the online compliance intervention program had not changed how income was assessed or debts were calculated.
Yes.
Well,
Why?
why?
Because that was my understanding, and I was thinking of it in the frame of when a recipient was able to engage with the system.
But I thought you agreed with me before that that wasn't even true.
Commissioner, I agreed that it was different, and I think I'm agreeing with you now on that. Back when I was writing this, I was thinking of it in the frame of when a customer engaged.
Is that a convenient time?
Yes, thank you.
2:30, all right? Or?
Yes, I think so.
Okay, 2:30.
All rise. The Commission stands adjourned until 2:30 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. Ms Campbell.
Look, I think there's an issue about a couple of emails that have a reference to some measures that aren't relevant to us but went to Cabinet, is that right?
Yes.
Anyway, what I was going to order was that the relevant exhibits be removed from the exhibit list and redacted exhibits substituted. Does that all make sense to you, Mr Flora? Sorry, I'm going over your head here.
I think the document might need to remain in the exhibit list but be redacted.
Sorry?
And the document would remain in the exhibit list but the document would be redacted.
Well, effectively, wouldn't it be better if they'll...
Commissioner, may I propose?
The physical documents, to the extent they exist, will be removed. Redacted ones will be substituted with the same numbers, yes. Okay. And there is a fleeting reference in the transcript, and I'll make a non-publication order to that. I think it's about 3 words in the transcript.
And we'll deal with that at the conclusion of today, Commissioner.
Thanks. Right.
Thank you, Ms Campbell. Do you have volume 3 in front of you?
Yes.
Tab 298, Exhibit 2532. This topic follows on from the message you sent to staff on 25 January 2017, which was touched on just before lunch. On 7 February 2017, you received an email from an employee of your department, Colleen Taylor, with various attachments which responded to your message from 25 January.
Yes.
And behind tab 299 was the first of the 3 attachments to her email, Exhibit 2533.
Yes.
And Ms Taylor emphasised that your message to staff was misled, and she described, that your message was inaccurate. And as she said in the paragraph, your statement tells me you are being misled, and I want to ensure my words reach you. Do you see that?
Yes.
Right. Did Ms Taylor's email and attachments to you lead you to change the message that that there had been no change to how income is assessed or debts are calculated?
No.
Why is that?
I asked Ms Golightly and Mr Hudson to review the message that Ms Taylor had sent to me, I think it was Mr Hudson, and asked them to go away and meet with her and work through the issues and come back to me.
All right. Ultimately, a response was sent to her, I think, signed by Ms Golightly.
There was a brief to me and a response to Ms Taylor from Ms Golightly.
Yes. But you knew at this point in time that there had been a change to the way income was assessed and debts were calculated.
So in 2017,
Yes.
I knew that, yes, at that point, yes.
Yes. So why didn't you change the message from your office as a result of you knowing that there had been, that there were changes?
I was focused on the engagement with the recipient and continued to focus on that engagement with the recipient at that time.
But your focus on the engagement with the recipient didn't stop you from acknowledging that there had been changes to the way income was assessed and debts were calculated?
For the period before then, I was aware of that and that we were putting in place mechanisms to ensure that the recipient was able to engage.
Yes, but even after that, it didn't stop you saying, yes, we have changed the way we do things, but we're focused on getting customers to engage.
Can you repeat that question, Mr Gregory?
Your focus on recipient engagement and the question of a change to the way income is assessed and debts are calculated are not mutually exclusive ideas, are they? They can both coexist. You can be focused on the recipient engagement, and you can also truthfully acknowledge that there has been a change to the way income is assessed and debts are calculated.
At that time, I considered if the recipient engaged, there was no change to the way, and provided information, there was no change to the way income was assessed or debts calculated at that time.
But why didn't you then change your message to say, in those circumstances there is no change, but outside those circumstances there is, if that in fact was the true position?
I don't know.
Were you really just sending a message to your staff that this was a departmental position, irrespective of what the truth was?
No.
Because, of course, by 25 January 2017, there had been a number of public criticisms by whistleblowers of the changes within Centrelink in terms of the assessment of debts under the OCI program.
Yes.
Right. And your response on 25 January 2017 was to rebut that suggestion that there had been a change,
Yes.
when in fact you knew that was not truthful.
Your question, did I?
You knew it wasn't true.
At that time, if we were able to get the customer to engage, I thought it was true. I accept it should have been caveated so.
But you can't explain why you didn't caveat it.
No.
It wasn't just a caveat, it was a fundamental change to a default position where ATO information assumed the greatest significance.
Your question.
It's not a small qualification, is it?
It's not a. If you're asking me, did I think it wasn't a small qualification, that it changed only when the customer didn't or the recipient didn't engage, at that point in time, we had stopped averaging. We were working towards a system that allowed the recipient to engage. And I, in hindsight, think that shaped my view of what we were saying at the time.
When you say you'd stopped averaging, you mean you had paused averaging?
We had paused averaging.
On page 2 of the response to the Secretary, you'll see the first dot point identified by Ms Taylor says much work was returned by quality checkers to be redone due to compliance officers not taking into account information already on the customer record, which shows that there is no discrepancy / no debt and the debt should be, or the debt should be lower. You see that?
Yes.
And below the paragraph number 3, rapid response from January 2016, you can see the second dot point asserts that the PAYG income was averaged without reference to the customer record. You can see that?
Yes.
And that's during the period when you said earlier today you thought averaging was not happening because it was a manual process. 1 July 2015 through to 30 June 2016.
I don't recall saying that, but I'm happy to review the transcript and see whether I have. I'm just trying to understand your question, Mr. Gregory.
Well, you understood, at least by this date, that averaging occurred in the manual process between 1 July 2015 and 30 June 2016.
Yes.
All right. And you understood that, I suggest, before that period started.
So this was averaging if the recipient engaged, or the averaging if the recipient didn't engage?
If the customer did not reply to the initial contact or was unable to provide pay slips or could not provide a credible adjustment to the start and or end dates on the PAYG summary, the compliance officers did not contact the employer for pay slips or pay report during that period.
This is in this document here?
Well, it's the first dot point under
Yeah.
rapid response. And I'm suggesting to you, you knew that prior to 1 July 2015.
Prior to 1 July 2015,
Yes.
that I knew.
What is set out in the first dot points, 2 dot points?
Oh, so this is under 3. Sorry, I was looking at the first 2 dot points on the page.
Right.
I can't recall what I knew in January 2017 of that level of detail.
I'm suggesting you knew prior to the commencement of the PAYG manual compliance measure on 1 July 2015 that where customers did not respond to the compliance officer's contact, averaging occurred.
I'm not sure I turned my mind to that level of detail.
All right. The third dot point under the heading Rapid Response from January 2016 refers to an instruction, a policy instruction, to no longer interrogate the customer record to explain the discrepancy. You see that?
Yes.
And for completeness on this page, the dot point which commences in the same area, about halfway down the page, see additional attachment in confidence emails. Can you see that?
Yes.
The last sub-dot point there says, as a compliance unit, we should not be the ones stealing from our customers, which was an email which was sent internally almost a year earlier. That was very strong language to be used by a staff member to the secretary about the online compliance program, wasn't it?
Yes.
That is, that a staff member was clearly conveying to you as the secretary that in the circumstances of this program, debts were being raised which customers did not owe and then being recovered. Understood that?
I did understand that, and that's why changes were being made to the system at the time I received this email.
And you would appreciate that on every occasion where averaging was used, there was a potential for an allegation of debt which was not in fact owed.
Yes.
And you knew that as at January 2017.
Yes.
But nonetheless, you persisted with the program which involved the use of averaging in circumstances where the customer did not respond.
Not at that time.
Well, it was resumed while you were DHS Secretary in August on your account.
Yes, when
All right.
I had received other information.
What other information?
When DSS had provided advice on the use of averaging.
What you're saying is that you understood that it was legal to allege debts which might not be owed and to recover the money.
I understood the advice from DSS.
Which was?
That averaging could be used as a last resort after attempts had been made to contact the recipient.
But that didn't change the practical understanding that you had in January 2017, that the use of averaging, either because of the confirmation of the correctness of the PAYG information or because the customer did not respond, created the possibility that a debt might be alleged which was not in fact owed.
From this response?
No, from your state of mind. You've agreed with me that as at January 2017, you understood that averaging gave rise to the possibility of an allegation of a debt which was not in fact owed.
The terminology "a debt in fact owed" is a little confusing in terms of what that means. If a debt is owed, it's a legal question, it's not a factual question. So the question is apt to confuse in my submission, the terminology of a debt in fact owed.
I don't actually see it. I'm sorry, Mr. Flynn. I'm going to permit the question to be asked.
So what difference did it make to your state of mind that DSS provided advice that averaging could be used in the last resort if in a practical sense it gave rise to the possibility that there was a potential allegation of debt which was not in fact owed?
I'm having difficulty following this question.
All right, I'll break it down. Your response to me about why you continued with the scheme was because you had advice from DSS that averaging could be used as a last resort.
Yes.
I'm saying, what does that matter if in a practical sense, DHS, when it uses averaging, is potentially alleging and recovering debts which are not owed?
I placed weight on the DSS advice.
So in your mind, you rationalised that it was lawful to average even though it might allege that a debt was owed when in fact it was not.
I placed weight on the DSS advice.
I don't dispute that you did, but my question is, how did you reconcile the advice that averaging could be used as a last resort with the practical consequence that you knew of in January?
I'm not a lawyer, and so therefore I did place weight on advice, legal advice that was provided to me.
Does that mean that because you aren't a lawyer, you accepted that averaging could be used lawfully with the potential to allege and recover debts which weren't actually owed?
I accepted the legal advice that was provided to me on the matter.
Yes, that doesn't answer my question, Ms Campbell. We'll be here a very long time if you don't answer it. Did you rationalise the practical effect of that advice with what you knew about the potential to raise debts which were not owed?
Mr Gregory, could you break the question into parts to allow me to better understand what you're asking?
I asked, and you would appreciate that on every occasion where averaging was used, there was a potential for an allegation of debt which was not in fact owed, and you said yes. You recall that question and that answer?
This morning?
Yes, since lunch.
That there was the potential? Yes.
Right. And I then asked, and you knew that, as at January 2017, and you said yes.
Yes.
And then I said, but you asked, but nonetheless you persisted with the program which involved the use of averaging in circumstances where the customer did not respond. And you said not at that time.
At that time,
Yes.
I was provided advice from DSS Legal that averaging was able to be used, and I relied upon that advice.
Yes, but that's a question of legality, correct? You got advice that it was lawful to average as a last resort, is your answer,
Yes.
as the explanation for why you started averaging again in August 2017.
Yes.
And my question is, how did you reconcile that legal advice that it was lawful to average with what you knew to be the case in a practical sense, that averaging had the potential to raise debts which were not in fact owed?
I relied on the legal advice.
So it didn't matter to you that the money might or might not be owed because you had advice to say it was lawful to do it.
So as the secretary, you do rely on advice from a range of people, lawyers, finance, ICT.
I don't doubt it, but doesn't mean you have to implement a system where you actually know that it might lead to the recovery of money from people who don't owe a debt.
So what I know and I balance so I can't recall that I thought the lawyers were wrong. So when I was given legal advice, I relied on that.
I'm not suggesting that you might have come to a conclusion the lawyers were wrong. What I'm suggesting is that irrespective of the suggestion that it was lawful, you understood the practical consequence that you might be recovering money, that is, your department might be recovering money from people who did not owe it. Just because you accept the legal proposition doesn't mean you continue to implement a scheme in those circumstances, is my point.
And your question, sorry, Mr Gregory?
Why did you continue to implement a scheme where you knew the potential was that money was being recovered which was not in fact owed.
Because I thought the legal advice allowed that to occur.
That is, irrespective of the practical consequences, you considered it to be lawful and therefore proceeded.
I relied on the legal advice that I was provided.
Irrespective of the practical consequences.
The practical consequences.
Well, the practical consequences were that somebody who had legitimately obtained a certain amount of benefit in, say, 2010-11, having correctly declared their income, might, as a result of averaging, be found to owe a debt. That was the practical consequence.
So, Commissioner, I think I didn't go into that level of detail. I relied on the advice that was given and went with that advice.
So would it be fair for you to accept then that prior to getting that advice, that you were not aware of a lawful basis on which you could average?
I don't know that I'd turned my mind to it.
You didn't turn your mind to whether the scheme that was supposed to recoup upwards of $1 billion was lawful?
Well, my premise on the scheme was that we would engage with the customer, that the recipient would be able to engage with, that the recipient would have the opportunity to provide updated information, and that averaging would only be used as a last resort. And so my focus was on the customer engaging with the system.
But you knew that that wasn't always the case?
What date are we talking about when I knew what?
From 1 July 2015 through until you say you received the advice that it was lawful?
I didn't turn my mind to it during that period.
Of whether the customer engaged?
Whether the customer engaged, no.
And you didn't turn your mind to the lawfulness of the scheme prior to that point?
No, because I had a very large department and I was relying on others to manage that system.
Well, you didn't, in the response that you approved to Ms. Taylor, indicate that it was lawful to average in these circumstances, did you?
What tab is that behind, Mr. Gregory?
There is a smaller supplementary bundle next to your water bottle. Tab 10. Exhibit 7036.
And the brief to me where you say that I approved it?
Well, you gave that evidence earlier that you got briefed on the matter and a letter was signed by Ms Golightly, so I'm taking you to the letter of Ms Golightly, cth.475.0029.0042.
I don't recall saying I approved the letter.
Is this Ms Golightly going off on a frolic of her own?
No,
Right.
my evidence, I don't recall my evidence was that I approved the letter. But if there's other evidence, I'm happy to look at it.
Well, do you see in the second line here, the Secretary has asked that I respond on her behalf?
I did ask that Ms Golightly respond on my behalf. I'm just looking for the evidence that you're saying that I approve this response.
Well, what's the difference between you asking Ms Golightly to respond on your behalf and approving the terms in which she responded?
Quite different.
Okay. Is there anything in here that you did not approve?
I will read it now and I'll see whether I can remember back 6 years ago.
You read the document now?
I have.
Yes. You referred to it in your most recent statement dated 3 March 2023.
Yes?
Right. So you're not having to cast your mind back that many years. You can only cast it back 4 days and you'll remember that you referred to it in your statement.
I can check my statement. I wasn't sure I said I'd cleared it.
Talking about remembering the content of it, Ms Campbell.
Okay.
And is there anything in here that you do not approve of?
No.
All right. And nowhere in here do you explain to Ms Taylor that irrespective of her concerns about whether DHS is stealing from its clients, DHS has legal advice that it's lawful to average.
Can I do that, answer that in part?
You can answer it however you wish.
I didn't write this letter.
Right. You delegated the job.
I did.
And you said that you wanted whoever you delegated it to respond to her concerns.
I did.
And there is no reference in here to a response which addresses the concern about stealing from clients, is there?
No.
There is no reference here to the legality of averaging.
No.
No. Right. In fact, the concerns raised by Ms Taylor are largely avoided in the response here, aren't they?
No.
I take you to Exhibit 2534 behind tab 300 in Volume 3. You see partway down the page in the columns which have blue arrows which run between them, the box which says scanned images, brackets, document tools in customer first. You see that?
Yes.
And there is a reference to checking for employment separation certificates. You see that?
Yes.
Right. You understood that the complaint made by Ms Taylor to you was that people are instructed by the policy to no longer interrogate the customer record first to explain the discrepancy.
No.
And can I take you then to the last page of that document, .5978. You will see IMPS, income maintenance period. The second dot point of this handy guide prepared by Ms Taylor was start and finish dates of employment may show all earnings from PAYG employer where prior to the grant of pension or benefit. This refers to an employment separation certificate. You can see that?
I can see that on the document in front of me.
Right. And if you go to the next tab behind 301, you can see a recitation of internal correspondence. That's the third annexure to her email, Exhibit 7022. And as the title of the document indicates and the explanatory paragraph immediately after conveys, this is internal correspondence from January 2016 in relation to changes outlined in her letter to you at point 3, concerns raised at the time and responses from policy. Do you see that?
Yes.
And a further reference to an employment separation certificate is there in respect of the second last paragraph on that page. Do you see that?
Yes.
That in circumstances where someone obtained a benefit partway through a PAYG period, they will often be required to provide a payslip or employment separation certificate to the department in order to obtain that benefit. You understood that when you read it?
I don't recall reading this document.
Do you understand it now when you read it?
Yes.
Right. And her concern was that the response in red was that compliance officers do not need to interrogate the customer record. You see that?
Yes.
Which rather proved her point that there was a policy that compliance officers were no longer to interrogate the customer record to explain the discrepancy.
That's what it says.
That's right. And that's what she asserted to you in January 2017 was the policy approach. What steps did you take to address these concerns about the question of interrogating a customer record to explain a potential discrepancy before a discrepancy letter was issued?
I referred the correspondence to Ms. Golightly and Mr. Hudson and asked, I'm looking for the referral. There must be a referral email by me.
Yes.
I've seen. Do we know what tab that is?
No, but you can give your evidence about it.
I referred it to them to look into the matter and to come back to me. I did not read the attached documents in detail.
You have a recollection you didn't read the attached documents in this email.
So I generally did not read documents that went to detailed workflows because I was not close to those sorts of workflows and I probably wouldn't have understood it. So that's why I would refer it to people who would understand it and would be able to provide me advice.
Weren't you very hands-on in early 2017 trying to remedy the defects? You were pretty close to the workflows by then, weren't you?
So I think this is the 7th of February, Commissioner. I think the documents sent, and so I think I was less into this at that time, but there is a document somewhere where I refer it to Ms. Golightly and Mr. Hudson, so I'm just seeing if I can find that.
But here's a source of information to you to tell you what's been going wrong. Why don't you leap on it?
I don't think I would have understood it, Commissioner, because it was a level of detail about workflows and documents which I was not familiar with. And so I thought it best that it be referred to someone who understood what each of these documents were, and that's what I did.
But from the sounds of it, you came to that conclusion before you even read it.
So I read the overall email, so when I got to the points where Ms. Taylor was talking about things like old style rapid response, and it was a very detailed email, I thought it was better that it be dealt with someone who understood the details she was providing, and that's why I referred it to others.
And did you take any steps to require a briefing to you that all of her concerns had been addressed in terms of the process issues raised by her which you didn't understand?
So I understand there is a briefing to me,
Yes.
and I don't have the reference. So I recall in preparing statements that there is a briefing somewhere, but I don't have access to it at this time.
I take you to tab 244. Exhibit 4724.
Are we still talking about my response to Ms. Golightly's response to Ms. Taylor, or have we moved topics?
Move topics,
Right.
sort of. Sorry, tab 243, exhibit 4725. Or 723. I'm not being any help to the document manager. CTH.3001.0048.8449. Thank you. You'll see at the bottom of the page, Mr. Stott emails you and Ms. Golightly, Mr. Aston, on 13 July 2017 at 8:46 p.m.
Yes.
To inform you that the Minister's office had been advised of an extremely sensitive topic, and that is that a DHS recipient took their own life, allegedly in response to an employment income confirmation letter.
Yes.
And they received an initiation letter on 2 June 2017 and a reminder letter on 20 June 2017, and took their life on 25 June 2017. And according to that person's sister, there was a suggestion of a connection between the receipt of the letters and her taking her life. And did you ask for an investigation to be undertaken in respect of the way in which DHS handled this particular file?
My recollection is yes.
And if you turn to 244, tab 244, exhibit 4724, you'll see an email which doesn't include you at all. It contains some additional information. Is this the investigation that you're referring to?
I've never seen this email before.
What form did the investigation take to your recollection?
I can't now recall, but I thought there was some correspondence that came to me and the Minister and asking for a review of what had occurred.
I haven't seen it, but you may recall it. You can see from this email at the top that Mr. Storen says, in terms of our review, there was a discrepancy in the data, therefore a review was triggered. It could have been resolved very quickly by the individual if she pointed out her employment ceased before the social welfare period. Similarly, it could have been resolved very quickly if the employment separation certificate that was on her record was accessed by the compliance officer and used to finalise the review. Neither of these things occurred, and we are looking at how we make that happen. Unfortunately, the employment separation certificate is not structured data, so I can't see how we can include it in any automation. I pause there. That clearly conveys, doesn't it, Ms. Campbell, that there was information on the customer record which would have explained the discrepancy?
Yes.
And it comprised an employment separation certificate?
Yes.
Which was raised specifically in an email to you by Ms. Taylor on multiple occasions in that one email with attachments in February 2017.
That was raised and passed to the area.
And it would seem unresolved in terms of process.
Yes.
What steps did you take after receiving information that there was information on a customer file which ought to have avoided the sending of a discrepancy letter and a follow-up letter?
I don't think I read the full extent of Ms Taylor's documents. I referred them to the relevant line area.
Right. And what about this? When you say you were asked for an investigation into it, what steps did you take to change process, if at all, after the suggestion that someone took their life after receiving a letter in circumstances where the department had the information which made it unnecessary to send the letter?
I don't think I received this email.
Well, what information did you get back as a result of the investigation you asked?
My recollection is that, and I'm trying to work out where I know this from, is that the department had been in contact with the recipient during this period.
Yes, but...
And was working with the recipient on this matter. But it could be, I may be confused because they're with another case, but I'm very seeking to be very careful about how I articulate what occurred in this very sensitive circumstance.
Are you referring to the document behind tab 242, Exhibit 4725?
No, I don't think I saw that either.
So there is other information that you are aware of, which is neither this document or the three which follow it.
My recollection, there was another escalation type email at some point about this matter, which was more of a summary of it.
Yes, but did it explain why, in terms of process, that the customer record was not interrogated before a discrepancy or follow-up letter was sent?
No, I can't recall.
And you can't recall then what steps you took to change the process in these circumstances?
No, but I note from this document, Mr. Storen indicates that they were looking at ways to address it.
Don't you consider it your responsibility, where you're in, as secretary, where you are informed that there is a suggestion of suicide linked to the scheme, that you should order a full investigation of the circumstances with a view to identifying process issues which may have contributed to the suggested association?
My recollection was that there was a review, and I'm now looking for the documents that relate to that. But I do note that the only documents I have been able to access are those that I would have seen at the time and that I've been able to track on my email. That has not included many documents. There have been many documents today I have never seen before. So I am just looking to see whether or not there is another document that summarised this case.
Yes, but a review and a summary doesn't really answer my question about what systemic changes you identified in the course of the investigation you asked for.
Finding that document would allow me to answer your question, Mr. Gregory, because 6 years on, I cannot remember every document that came to me.
I'm not suggesting that you have to, but you've been preparing for this evidence for some time and the relevant documents have been identified for you.
So I'm happy to review that relevant document.
They are before you. I've taken you to them.
But these documents I have not seen before today because they were not sent to me at the time, so I have not had access to them. I was not provided them last night. I'm looking at them now.
Do you accept that the delegation that you made in respect of Ms Taylor's complaints about process, including the need to interrogate the file, were not followed up by whoever you delegated it to and addressed in a systemic way?
Yes.
And do you as Secretary take responsibility for that?
As the Secretary of the Department, I'm responsible for the actions of the Department, but I cannot possibly put myself in every one of the 20 or 30,000 people's shoes.
True, but it was your choice to delegate an email which was directed to you, in which strong language was used by someone who had experience with how the system was working.
Yes?
Right. Do you think your investigation identified the failure on the part of your delegate to address this systemic issue raised in February 2017?
No.
Can I just ask you this? In January 17, it became apparent to you that there were problems with people even being contacted before averaging was applied. Is that right?
There were problems with people being able to access people, get letters to people, talk to people.
Yeah, people had had averaging applied who first heard about it from a debt collector.
Yes.
All right. So knowing that over the last couple of years people were in this situation where averaging had been applied and they hadn't had the opportunity to respond, what did you do about that?
But they hadn't had the opportunity to respond, so we paused averaging.
Sure, but what did you do about the people who'd had averaging applied against them when they hadn't had the opportunity to respond?
So my recollection is we offered a review of those debts to everyone who had not been able to be contacted.
So you contacted every one of them and offered them a review?
That's my understanding.
All right. You didn't say, we'll set aside the debt and start again?
No.
Ms Campbell, can you turn to tab 234, please? Exhibit 6983. Now, this is an email from Bevan Hannon, who was a person in the media area, to you and Ms Golightly and others. Where he says, "Hi Melissa, we had a suicide issue recently which gave us a good basis for lines on this type of matter." The tenor of the email, Ms Campbell, suggests that the suggestion of suicide was just a prompt to develop a media response rather than a call for any meaningful review of the system. Did you tolerate that tone?
No.
What did you do about it?
So within the Department of Human Services, sadly, suicide was something that we dealt with frequently. And I do not accept that it was a media management issue. There was a team of social workers and a delivery and a service response team who dealt with people and the families around those who had died by suicide. There were some 700 social workers, and they worked closely with those families because we understood that this was a very difficult place for people to be. And I'd like to be really clear now to people who are listening that the government did not think suicide was the answer to receiving one of these letters. And there are many people in the Services Australia who can assist people with receiving such correspondence. But I want to be very clear that we understood the tragedy of suicide and worked hard to support those people who were around a person who died by suicide.
Yes, but it didn't cause you to reflect upon the scheme in which these letters were being sent and consider whether it was appropriate to send letters where averaging might give rise to debts which were not in fact owed.
My understanding was on the other case that it was an initial letter that had been sent. I understood that a compliance officer had engaged with the recipient and was talking with them, that a people-to-people engagement was occurring at that time.
So what difference does that make if none of that should have happened because the compliance officer ought to have interrogated the information on the file?
So it would have been preferable, and that was something that was identified, that they could have found that beforehand, but we don't know whether that was the only, if that would have made changes to the fact that there were still matters to be considered. I don't know that to this day.
All right. Can I take you back to volume 3, tab 241, exhibit 4722. This is an occasion where the Minister asked for an investigation or review of the file relating to the suicide of Reece Corso. Do you recall this event?
Yes.
And was a review conducted for the purpose of being able to provide some assurance that the department acted appropriately?
The review was conducted to understand what had occurred.
Can I take you to paragraph 39 of the brief, page .0595. You know that a JCA is a job capacity assessment,
Yes.
and it communicates that it was information on the Centrelink file.
Yes.
And on this case, on 18 September 2015, Mr Corso attended the job capacity assessment for a disability support pension claim.
Yes.
And the medical conditions which founded his application were listed as anxiety, depression, fully diagnosed, treated and stabilised with an impairment rating of 5 points being assigned. And that the assessor noted Mr Corso reported suicidal ideation but denied having a current plan or intent, and there was the discussion of a safety plan with the psychologist. His assessment was less than full-time work, you can see that, 23 to 29 hours per week.
Yes.
And yet, despite Centrelink having all of that information, no vulnerability indicator was recorded on his file.
No.
Why not?
I don't know.
It ought to have been.
I don't know how many JCAs are completed every day throughout Australia, and I don't know how many were completed on the 18th of September 2015. But a person made a mistake.
And you wouldn't think that was a small mistake, would you?
No, but in a system of some 30,000 people, sometimes they make mistakes.
I take you to the letter drafted and signed by the Minister .0597, you'll see the fourth paragraph says, the review identified some minor errors of an administrative nature.
Which tab number?
Oh, it's the same tab, it follows on from the brief. Yes, sorry.
Okay.
Tab 241. You can see the letter there signed by Mr. Tudge,
Yes.
and you can see the fourth paragraph
Yes.
where it is asserted that the review identified some minor errors of an administrative nature, but concluded that both the department's and its agents' interactions with your son were handled appropriately, professionally and sensitively. Do you see that?
Yes.
How is it, Ms Campbell, that a failure to record a vulnerability indicator in respect of someone with mental ill health which involves prior suicidal ideation can be described as a minor error of an administrative nature?
I don't know.
Because, you know, had a vulnerability indicator been recorded, his alleged debt, using averaging, would not have been assigned to a debt collector.
Yes.
These were not genuine reviews, were they, Ms Campbell?
Yes.
They were undertaken to deal with potential media criticism of reporting in respect of suicides said to be associated with the scheme.
No.
I'll take you to tab 236, volume 2, exhibit 6984. And the last email in this sequence is your response to the media article relating to Reece Corso in the Saturday paper on 18 February 2017. And you were informed by Ms Golightly that the Saturday paper updated the story but has not used most of the info we sent them today. They do include that it was a manual process right at the end. But after this, there is the whole body of the report which still implies it is all to do with OCI. Do you see that?
Yes.
And your response was, from now on, I want to be more direct with media outlets when a recipient or representative makes claims which are inconsistent with our records. After getting legal advice, I want to say the information is inconsistent with our records or some other form of words. Do you see that?
Yes.
And you said that before any review, any genuine review could be undertaken in respect of the Centrelink file and the circumstances in which Mr Corso and Mr Corso's alleged debt was assigned to debt collectors.
So I think these comments weren't made necessarily in response to Mr Corso's tragic death, but more in the vein of trying to get out of providing comment on recipients and their details. So my comments were about, I don't want to engage with the media on a line-by-line issue and people's details anymore. I just want to be able to say these comments don't accord with our records and leave it at that. The comment also says this may require a discussion with the Minister's office, because at this time I didn't think there was any value in engaging in this manner.
What you don't say is in circumstances where a death is alleged to be associated with the scheme in some way, I require a full investigation as a standard practice.
Not here,
No.
but I don't know. So my recollection is that when there was any suicide that involved an engagement with the Department of Human Services, that there was a review. The Department of Human Services managed a number of programs, including the Child Support Agency. And sadly, there were a number of suicides reported with that program regularly. So that was standard practice, that when that occurred, a review would be undertaken.
There seems to be indignation here that the reporter might have suggested it was in connection with the online compliance program, when in fact it was the earned income intervention scheme, as if that made a difference. And this seems to pop up in other spots too. Oh, it wasn't OCI, it was a manual intervention. And it's hard to see how that helps. You see what I'm saying? This email, from the complaint from Melissa Golightly to you, is about the Saturday paper only including the fact that it was a manual process right at the end of the article, but the body of the report implying it was OCI. Now, how could that possibly help or improve the situation that it wasn't OCI?
So I think at this point in time, the staff were feeling that they were under siege as well, Commissioner, and I think they were trying to say it's not an OCI issue. Of course, it didn't matter what, if anything, what had contributed. This was a tragic circumstance. But the staff were, by this stage, pretty tired, and I think that might have been why some of that tone had snuck in.
But why would it be better if it was the pilot for OCI as opposed to the OCI?
I think at this stage the criticism was about the automated nature, and I think the point that the officers may have been trying to make was that this was a person-to-person engagement.
But still averaging. All right, doesn't matter. Mr. Gregory.
Thank you. Ms Campbell, you were aware that the Australian Council of Social Services called on the Minister for the scheme to be paused pending the Senate investigation and the Ombudsman's investigation.
Which tab are we at, Mr Gregory?
I was talking about your recollection of events.
I recall that there was correspondence from ACOS. At that time, yes, there was correspondence from ACOS.
And one of those is behind 282. Exhibit 2002, where you were forwarded... Sorry? Yes, 2002, where you were forwarded an email with an attachment, and the attachment included a large number of online statements and reports in respect of the Online Compliance Intervention Scheme, and the update was that ACOS issued a media release arguing the government must abandon Centrelink's auto debt recovery program to prevent further harm. Tab 282.
I have the media elements, but I'm just looking for the press release from ACOS.
Can you see the email at the start?
I can. And it says in that email, attachment, ACOS media statement. Oh, it's a media statement, not a media release.
But irrespective of the criticism raised by ACOS There was no suggestion as between you or the minister that the scheme would be stopped because of the questions identified by ACOS about inaccurate debts or any sense of general unfairness.
So at that time, the averaging had been paused.
What day was that?
I can't recall when it was paused, or it was about to be paused, or maybe, I'm not sure what the date is, but in January or February it was paused while improvements were made to the system.
And did those improvements remove the prospect that debts would be raised and alleged and recovered, which were not in fact owed?
The measures at that time were to increase the ability for customers to engage.
This scheme was commenced by your department without any compliance with the Office of the Australian Information Commissioner's guideline, voluntary guideline on data matching. Is that correct?
I don't know.
What steps did you take in respect of your department to make sure that it complied with the voluntary data matching guideline?
I relied on others to do that.
Particularly who?
Ms. Golightly.
And so to the extent that there was non-compliance with the guideline, you accept responsibility for that as well?
I delegated that to an officer within the department, and if it was not compliant, I am unable to add any more.
Can I take you to tab 327, exhibit 7048? These are emails between people within your department, and the context here is a media request about the Office of the Australian Information Commissioner's guidelines and compliance with them. If you go to the email at the bottom of the page, you'll see Ms. Golightly emailed Mr. Clark and others, noting that the reference to a statement by the Australian Information Privacy Commissioner on the previous page conveyed potentially that the assessment is not finalised, and that could be interpreted by commentators as we released a system without having a privacy assessment completed, and that will cause a huge problem for us. You returned from leave, I think, on 10 January 2017.
Yes.
And were you briefed by Ms. Golightly in respect of the question of whether your department had complied at all with the guidelines issued by the Information and Privacy Commissioner?
No.
The response as it was developed in the following tab, tab 328, exhibit 7049, by Mr Hannon in the highlighted section is that the department works closely with the Australian Information and Privacy Commissioner on a regular and routine basis in relation to our data matching activities. The OAIC is presently working on an assessment of our compliance activities. However, this does not relate to the online compliance interventions currently the subject of public discussion. Do you see that?
I see that today for the first time.
And if you turn then to tab 330, Exhibit 7051, you'll see that that media response is attributed to Mr Hank Yongan, who was the media spokesperson for the department. That's
Yes.
correct? And so, as at early January 2017, it's the case that you had no knowledge that either the data exchanged between DHS and the ATO complied with the voluntary guidelines. That's right.
No.
And you had no knowledge that the process of averaging was lawful.
Which day are we talking about?
Early January 2017.
When I returned from leave.
Yes.
I think I was in the process of finding some of that stuff out.
What you found out when you returned from leave in the debrief with Mr Barry Jackson, who acted in your position while you were on leave, was that he gave instructions for the department to develop a request for legal advice to the Australian Government Solicitor in relation to the lawfulness of averaging.
I don't recall that.
You recall the handover with Mr Jackson?
No.
Well, there must have been one.
My recollection is I returned from leave that day and went straight to Parliament House. I don't recall a handover with Mr Jackson other than I'm glad you're back or something like that.
Well, it wasn't the average period of Christmas leave in respect of all being quiet within the department, was it?
No, but I was engaging with Ms Golightly.
Why wouldn't you engage with the secretary who acted for you while you were gone to find out what, if anything, was in train in respect of the public criticisms of the scheme, which included legality?
Because I was talking to Ms Golightly, who was closer to the topic.
How did you know she was closer to the topic if you didn't talk to Mr Jackson about it?
Because on my leave, I had seen the media. It's not as if I had not seen anything, and when I came back, I spoke to Ms Golightly. I spoke to Mr Jackson as well, but I don't recall it being a formal handover briefing. And of course, there were other things happening within the department as well that required attention at that time.
I'd ask that Exhibit 6856 be brought up. It's not in any of the material before you, Ms Campbell, in hard copy. It is an email from Ms Golightly to Mr Jackson, Saturday 7 January 2017, in which she says that she's on the phone to you because, well, you called her. You see that?
Yes.
That is, you were staying in contact with Ms Golightly about what was happening while you were on leave?
No, because I'd had limited phone coverage, and I think I only had phone coverage on the Saturday and Sunday.
Are you saying that Ms Golightly did not inform you at any point after your return that Mr Jackson had in train the process of obtaining advice from the Australian Government solicitor for the week of your return?
No, I was unaware of that. I haven't seen this email before. Is there more to it?
Can you explain then why evidence before the Commission that Mr Jackson had taken those steps, that is, that legal advice be obtained from AGS, did not progress after you returned from leave?
I didn't know Mr Jackson had made the request.
Follows then that someone who was not you stopped what was in train.
I didn't know Mr Jackson had made the request.
Yes, I understand that. And you say Ms Golightly never told you anything about it?
No.
And Ms Sue Cruz never told you anything about it?
No.
Ms Mussolino never told you anything about it?
No.
Mr Gladman never told you anything about it?
I don't know who Mr Gladman is.
Sorry, Mr Menzies McVeigh?
No.
What do you say to the evidence that this Commission has heard from Mr Jackson that he provided verbal advice to you that he'd raised the issue of legislative authority with respect to averaging with Ms Golightly, who advised him that she was progressing his request?
I don't recall that.
If it happened, Ms Golightly did not progress the request or inform you of it?
I don't know.
I take you to Volume 1, tab 145. Oh, I'm sorry, it's Volume 2. Exhibit 5107. Ms Campbell, this is an advice from Glenn Fiveash, Deputy General Counsel, 11 January 2017, to the effect that the Department cannot apply an income amount received over a larger period in any way against a customer other than the manner in which the person received it in those individual fortnights. Do you see that?
Yes.
And if you turn to tab 144, Exhibit 5106A, you'll see that he forwarded that advice to Ms Musolino on 23 January 2017 in response to her request to various Deputy General Counsel to identify and provide any legal advices regarding the debt recovery of Centrelink overpayments and specifically about the online compliance system. Did Ms Musolino ever tell you that she had requested and received advice from one of the Deputy Counsel within your department to the effect that averaging could not be used to raise debts?
No.
Now that you know that it existed, would you have expected that Ms Musolino ought to have informed you of that?
I don't know what was in Ms Musolino's mind and what other advices she had.
Would you require her to inform you, in terms of your state of mind, if she did receive legal advice from within your department that averaging could not be used to raise debts?
I don't know what was in her mind and what else she had access to.
Yes, but I'm talking about your state of mind. Was it important for you to know that if a lawyer in your department had provided advice that debts could not be raised by averaging?
Yes.
Right. And you say this was kept from you?
I have no recollection of this. I have found nothing in my emails or the documents that have been provided to me.
Can I take you to tab 150? Exhibit 4831. I recall being informed by Mr Hudson that there was an Australian Institute of Administrative Law conference in Canberra 20 and 21 July 2017 in which various presentations were to be given which touched on the question of the debt recovery scheme operated by your department.
Yes.
And do you recall that it was regarded within your department, that is by you, that it was a sensitive topic?
No.
Can I take you to tab 156, exhibit 5833? Sorry, 4833. You received an update on it from Ms Musolino 20 July 2017 at 8:41 p.m.
Yes.
And she informed you that Mr Hanks in QC spoke at the conference, that his speech was extremely critical, that the matter should be looked to find a test case in the federal court.
Yes.
that your statement that customers, that initial letters are merely clarification letters when customers are forced to engage or have debts raised against them is an implausible position.
Comments I made at Senate estimates.
That the raising of debts using averaging is not consistent with the terms of the Social Security law. You can see that criticism.
Yes.
And suggests the law provides no scope to put the onus on the customer to provide information that they do not owe a debt. What steps did you take to satisfy yourself that the scheme was lawful following those public criticisms by someone of Mr Hank's experience in the area?
I was unaware of Mr Hank's experience in the area.
Did you not inquire?
No.
Why not?
It didn't occur to me. I was unaware of what Mr Hanks did or his standing.
You were not interested to find out whether the criticism was from someone who obviously knew what they were talking about or not?
I didn't understand Mr Hank's background.
That's not my question, Ms Campbell.
No,
You were not interested to find out, were you?
I did not find out.
You weren't interested to find out, were you?
No,
You knew at least he was a QC,
I did.
which is a bit ahead of anybody likely to be in the DSS legal department. You're relying on their advice.
I did rely on their advice.
Okay, well, this is a QC. They're not going to be a QC, are they?
At that point in time, I put more weight on the advice from DSS than on the outcome of a conference.
Had you actually seen the advice from DSS?
I'd seen, at this point in time, by July 17, I'd seen the letter from Mr Pratt.
Mr Pratt's not a lawyer, I don't think.
No.
Okay, what's that got to do with it?
He was the Secretary of the Department of Social Services, and his letter to the Ombudsman, I placed greater weight on that than I did on the summary of a legal conference.
Knowing that his statement was likely to be based on the same advice you're relying on from somebody in the DSS legal department?
I placed more weight on Mr Pratt's advice than I did on the feedback from a legal conference.
But there's a real issue here. It's not just a matter of which you attribute more weight to. Don't you have a responsibility to inquire about this?
In hindsight, it would have been preferable for me to have contacted Mr Pratt at this stage and told him that we needed to get independent legal advice. I accept that now.
Okay.
What you're saying is that irrespective of the number of people anticipated from whom it was expected that debts would be recovered, that you were prepared to rely on a letter written by Mr Pratt to the Ombudsman.
I was prepared to rely on DSS's advice, yes.
Are you talking about something different to what I just said?
Can you repeat your question, Mr Gregory?
You were prepared to rely on the letter written by Mr Pratt to the Ombudsman,
Yes.
and you appreciated that the Ombudsman was not squarely addressing the question of legality.
No.
Aren't you just turning a blind eye to the difficulties with the scheme which you knew existed at that point in time?
No.
That is, you didn't want to get advice because you had an idea of what it might say.
No.
When you became Secretary of the Department of Social Services, your department received an advice from an external legal provider, Clayton Utes, on 14 August 2018 in respect of an AAT decision where it was assessing whether an appeal should be conducted. And I take you to tab 167 and 168. (4190) and 4191. Do you accept that your department had advice, that is, while you were at DSS now, with responsibility for all of these things that you say DSS had, and your department was in possession of this advice as at 14 August 2018?
Yes.
To your knowledge, was this advice shared with the Department of Human Services?
I don't know.
Or was it brought to your attention?
No.
Can you explain why an advice which said that the process of averaging did not have a lawful basis, in effect, would not be raised with you?
No.
It ought to be raised with you, shouldn't it?
Yes.
It ought to be raised by the Chief Counsel at the time.
Yes.
Was it the case that you projected to your departments, both DHS and DSS, that you were not interested in getting legal advice at any time in respect of the matter?
No.
Do you accept responsibility for the fact that from August 2018, your department had advice which said that it was not lawful to average, and yet the scheme continued?
There was advice in the department that I was not aware of.
And you are responsible for that advice staying hidden in the department?
I was unaware that that advice existed until November of 2019.
And when you were at DSS, you never asked for advice to be given in respect of the lawfulness of the scheme?
To what time frame are you talking, Mr. Gregory?
Well, from September 2017 to December 2018. What about that period?
No, I did not ask. No.
Even though you knew it was your department's responsibility to obtain advice about whether the scheme was lawful or not?
I don't recall the matter arising in that period of time.
Well, at least you had the awareness that there was a question which had been raised while you were DHS Secretary by Mr Hanks in public about the lawfulness of the scheme.
Yes.
And you relied then on Mr Pratt's letter to the Ombudsman as a basis for continuing it and not asking further questions, correct?
Yes.
But when you were Secretary of DSS, did you take steps then to ascertain what advice existed within DSS which might have supported Mr Pratt's letter to the Ombudsman?
Not at that time.
Why not?
It was not a matter I was focused on at that time.
Mr. Gregory asked you before about what you might have projected to members of the two departments in relation to legality. I want to put it to you more broadly. Do you think you may have projected to members of those departments that you didn't want to hear anything which questioned the appropriateness of the scheme, which produced massive savings for government?
No.
Right. You do seem to have been very shielded from a lot of bad news, would you agree?
There was a lot of bad news got to me on other topics. There was bad news most hours of most days in those departments. Commissioner?
Right.
No doubt you got paid very well to handle bad news.
What was the question, Mr. Gregory?
The fact that you might get bad news is all the time is no reason for it not to come to you, is it?
No.
No. And yet bad news in respect of this scheme never seemed to make its way to you.
I think there was bad news on this scheme that made its way to me.
Do you agree that from January 2017, instead of taking the obvious step about getting legal advice, you engaged in a full-scale defence of the lawfulness and fairness of the system over the remaining period of your duration as DHS Secretary?
If your question is, did I not get any advice, I have provided evidence that I did rely on the DSS advice.
The letter to the Ombudsman?
And before that, my understanding was that DSS had advised officers within DHS that they thought it was legal. And that's what I relied on. And I also relied on the administrative arrangements orders, which gave responsibility for the Social Security Act to DSS, and I relied on the legal services directions which suggested that we should go, which required us to go to DSS before seeking legal advice. I accept, having received some of that feedback, it would have been preferable for me to contact Mr. Pratt and say that we would get independent legal advice.
What document can you point to say you understood DSS had advised officers within DHS they thought the scheme was lawful?
I cannot point to a document. It was part of conversations in early January.
With whom?
Ms. Golightly.
And did you make a record of it? It
No.
was obviously a significant conversation in light of the criticisms at the time.
There were many conversations over a compressed period of time.
This was obviously a significant conversation in light of the criticisms at the time.
Yes,
Right? But you didn't make any note of it?
not that I have found.
You didn't ask Ms. Golightly to provide a brief to you to that effect?
No.
There were many briefs about many aspects of the scheme, but none which dealt with legality, were there?
My recollection that there was emails from DSS, but I can't recall a specific time when it was notified.
You did become aware in 2019 that DHS was engaged in litigation, where Mr. Hanks was the barrister, in a matter of Masterton.
I was unaware who was the barrister.
That is, that a test case was being run in the federal court. You were aware of that.
Yes.
If Exhibit 7072 could be placed on the screen, it is a DHS-DSS Secretary meeting agenda, Ms. Campbell, which has the date Friday 3 May 2019 in your office, and there are various leads indicated in the right-hand column, either yourself or Ms. Leon. The seventh item is Masterton and the Commonwealth. Did you ask Ms. Leon at that point in time whether she had advice about the prospects of success?
I don't recall, and I have asked for the minutes of these meetings from the Department of Social Services and they have not been able to provide them to me. I don't recall what happened at that meeting. I don't recall whether the meeting occurred. I expect it did either then or at some point in time. And at this point, officers between DSS and DHS were engaged in discussions about seeking advice on the matter.
This was May 2019, a much more recent event than the events of 2015, 2016, 2017 or even 2018. It was the first challenge to the lawfulness of the scheme in the federal court.
Yes.
No doubt in your mind that was a significant question which had to be answered, and you're saying you cannot recall what was discussed.
I recall that there were discussions between officers of our departments on getting advice on the matter.
I take it you do not recall asking Ms. Leon whether her department had received advice in respect of prospects of success.
I don't now recall what I knew on the 3rd of May versus what I knew in November of 2019 when I understood that there was AGS advice to DHS at the end of March or the start of April. So I don't now recall whether I knew that in May.
Do you recall telling Ms. Leon at some point after she assumed the role as Secretary DHS that the OCI program was essentially your idea and that more budget savings could be gathered if she looked further into untouched areas within the scheme?
No.
Did you have that view that you were the person from whom the idea was generated and propelled?
No, and I have never said that.
You have a recollection that there was a delay in the provision of the Solicitor General's advice to your office,
Yes.
but you can't recall whether you asked for Ms Leon whether there was any advice at this first meeting, it seems, about Masterton and the Commonwealth.
I'm just trying to understand your question. It's a two-part question?
Well, in the premises where you can clearly recall that you asked for, through your staff, a copy of the Solicitor General's advice, and there was a delay of about 5 weeks in providing it to you after it was received. How is it that you say you can't recall whether you asked Ms Leon for whether she had the Masterton advice in May of the same year?
So there was correspondence about the first matter, and I considered it so shocking it was hard for me to forget. And there was correspondence between myself and Ms Leon about the failure to share the Solicitor General's advice. So that's why I can remember it well. With respect to this meeting, I've asked for the minutes. DSS have not been able to provide them.
You have no corresponding emotional response to the idea that the Masterton advice, which existed at the end of March, was not provided to you?
Provided to me,
Yes.
I do have a recollection that Mr Bennett, who was the First Assistant Secretary in Social Services stream, at some point in time told me that there was advice on Masterton that put into doubt the original DSS advice.
And you don't.
I do have a recollection of the emotional response to that by being horrified by that.
Horrified by that? And when was that?
Somewhere after, between when we worked with DHS on finalising the Solicitor General's questions and when the advice was provided to DSS from DHS. DHS received it, I think, in end of March of 2019, and then the departments worked together on the questions.
You're referring to DSS receiving the advice in Masterton at the end of March?
I'm not sure whether what date we received it.
And when you say work together on the questions, you're talking about the engagement in August 2019 in respect of the questions for the Solicitor General?
Yes.
Right. You don't recall a sense of delay in the same way that you recall it in respect of the Solicitor General's advice?
The delay between
Any request for the advice in Masterton and the provision of it?
So, yes, I do think there was a delay there, and I think one of the reasons had something to do from DHS's perspective with being in caretaker mode, but I can't now recall when I had that discussion with Mr Bennett.
You recall that your department, and that is DHS, in February 2017 engaged PwC to conduct a review of the online compliance program?
Yes.
And that followed meetings between you and Terry Webber?
I think it was a phone call with Mr Webber. I can't recall.
Mr Webber was someone you'd known for some time?
Yes.
Years, perhaps?
Your question again, sorry, Mr Gregory.
You'd known Mr Webber for up to some years?
Yes.
And you socialised together on occasions?
On occasions, yes.
Did you have authority to approve a particular level of expenditure without going to a formal tender in respect of consultants?
My recollection was there was a panel arrangement that the department could use for selection of some providers.
Without a formal tender process?
So the panel arrangements were established so that a formal tender process was not required. So there was a tender process for the panel, and then people could be asked for quotes off the panel.
And the authority to approve expenditure in respect of an external consultant, was that limited in any way within your delegation?
I cannot now recall. I think it was. There was delegations at the First Assistant Secretary, Deputy Secretary and Secretary level, or even maybe the Assistant Secretary level.
In any event, you agreed to the engagement of PwC following your call with Mr Webber?
I agreed that PwC, a partner, would speak with the relevant area within DHS about the engagement. Right. I had identified a need, but I had delegated to someone with more detail about what the actual requirement would be.
No report was produced to the department despite it being identified on the works order as a key deliverable. Can you explain that?
No.
There are records within PwC which indicate that the department wished for the report to be marked Cabinet in confidence in late April perhaps, or early May. Can you say anything about that?
No.
Of course, there wouldn't be any basis to your knowledge to mark a document like that, would it?
Unless the Minister had proposed to take it to Cabinet.
Yes. And in your preparation here, you haven't identified any such document?
No.
The value of the work to be undertaken by PwC exceeded $900,000. In circumstances where they worked on a report to the penultimate stage, there is a suggestion, or rather an inference available on the evidence, that someone from the department communicated that they didn't want to receive it. Did you give that direction to anyone?
No.
Did anyone tell you that they made that decision?
No.
Would you expect as Secretary that if the department had paid that sum of money to include a key deliverable of a report, it ought to have been produced?
Yes.
And you can't explain why it was not?
No.
Were you
ask any questions about where's the report?
No, I remember seeing PowerPoint slides. I wasn't fixated on a report. We had engaged PwC to help and change things as it went, and I remember seeing a range of PowerPoint slides, in particular that had been presented to Minister Tudge. So it wasn't something I was waiting for because of the, I think I called it a find and fix nature of the contract.
Mr Gregory?
Yes, thank you. You said earlier that you don't have any recollection of being provided information about the pilot program. You're aware that a pilot was conducted, I think, in respect of approximately 1,000 people in late 2015?
2015? No, I...
Sorry, approximately July of 2015.
I don't recall.
Do you remember that following approval of the budget measure in May 2015, the department engaged in a pilot program?
I don't recall that.
Moving forward to 2017, do you recall receiving the initial response from the Ombudsman's investigation and saying that you weren't satisfied with the approach taken by the Ombudsman?
Is there a document I can refer to?
There are, but do you have a recollection of that fact?
I remember, I don't know whether it was the Ombudsman, but I remember Mr Hudson, in preparing for this, that Mr Hudson and Ms Golight, Mr Hudson had said the report's in and it's okay, and I read it and said I thought there were some shortfalls in the report that we had not provided advice to the Ombudsman on.
Yes. And one of the points that you made to Mr Hudson and Ms Golightly was that in fact the department had engaged in a pilot, an end-to-end process.
And I think I would have been very focused on that at that time, but it's not something 6 years later it comes to mind.
Sure, we can locate the document if we need to, but it indicates at least your knowledge that the department had engaged in a pilot program.
In 2017, I expect I had that knowledge.
Yes.
But
all right.
It is not something I have retained since.
All right. I'll have some documents brought up on the screen for you. Exhibit 5656. It is a draft minute to you through Ms Golightly, prepared by Mr Withnell. It identifies a critical date of 10 July 2015, and the reason is to provide you with timely advice according to the draft.
Is it possible to enlarge that screen?
I'm sure it is,
please?
if the passage below the issues could be enlarged, yes. Thank you. And if we could turn to the second page. And if the passage from the top commencing staff feedback could be called out, thank you. And if the next passage of the page could be called out, commencing as part of the pilot, thank you. You can see that one of the results of the pilot in respect of the circumstance where a letter was tested, designed using insights from behavioural science, led to approximately 60% of recipients not contacting the department. You see that?
Yes.
Now, if I take you to Exhibit 5658, this was an email. It's not in your bundle, it's in Mr Withnell's bundle.
Can I just clarify, did I receive that brief?
We're coming to it. 5658. If the top part of the document could be called out. Thank you. The draft brief was dated July 2015, and as at November 2015, you can see a decision was made at some point by someone that the brief was not to be sent to you. Firstly, you've now seen the information obtained as part of the pilot. You accept that it was known to your department as at July 2015 that there was a very high non-response rate to letters sent as part of the pilot.
Yes.
And that averaging would be applied if those percentages held true in a large majority of cases.
Yes.
Can you explain why someone, somewhere, somehow decided not to give you that information?
No.
It's obviously very relevant, isn't it, to the way in which the department conducted the program?
Yes.
Because it impacts the way in which debts are calculated using averaging.
Yes.
Who's Jenny Spokes? Do you know?
No.
And business integrity briefs. Do you know who's involved there?
No. There were like 30,000 people in the department, so no, I didn't know who these people were.
The document we referred to earlier is behind tab 230, exhibit 1332. This is your email to Mr. Hudson and Ms. Golightly in respect of that first exchange, in respect of an outline of the draft report from the Ombudsman's Office. And in your email at the top of the page, you refer to a number of issues that will need rebuttal, including end-to-end testing, brackets, i.e. the pilot, and you continue. It tends to suggest you had information about the pilot within your knowledge at that point in time.
I had knowledge that there had been a pilot.
Yes. One possibility is because of the high number of non-responses to the letter, that it was considered best to communicate the substance of the information to you orally, that is not in writing. What do you say to that possibility?
I have no recollection of that ever occurring.
Do you recall that following this point in time, your department, particularly Mr. Hudson and Ms. Golightly, engaged with the Ombudsman in a highly invested way to ensure that, as far as possible, there was little criticism by the Ombudsman of the OCI program?
If you mean by highly invested, they provided advice and information about the program, yes.
And to the extent that they drafted parts of what might become a report if the Ombudsman would adopt it?
The Ombudsman's final report was a matter for the statutorily appointed Ombudsman. Input provided by agencies, in my experience, would be considered by such office holders. But it was ultimately the Ombudsman's report.
Do you recall having meetings with the then Ombudsman about the scope of the inquiry?
I can't recall.
Do you recall having meetings at all with the then Ombudsman about the inquiry?
No, not in 2017,
17.
no. But I haven't been able to access my diary.
Thank you, Commissioner. I think that's the evidence.
You told me earlier that you would consider what advocates said so you could understand what their issues were. This is advocacy groups, that you're anxious to understand what their issues were and respond appropriately. What were your dealings with ACOS?
ACOS had a regular meeting with myself and a regular meeting with the minister that I attended.
And in 2017, did they seek a meeting with you in the early part of that year? And did you hold it with them?
I recall them seeking a meeting with the minister, but I can't recall whether there was a separate meeting with me. It was a joint meeting with the minister.
And your attitude to ACOS?
I listened to ACOS's proposals.
All right. There's an email where you speak of a transcript of an ACOS interview. I haven't got the reference number, but I've seen it in the material. Can you help me with that, Mr. Gregory?
Yes, one moment.
Oh, perhaps it doesn't matter. I'll go on to something else. Now, there was some discussion of Mr. Fiveash's advice before. You don't need it, but you recall Mr. Fiveash had written an advice in the department. You did not see it. But Mr. Fiveash has given a statement, and one thing that he says in it is that he recalls you would generally commence conversations with, what is the legal basis for this? You're talking to a lawyer in that instance, of course. But was it typical of you to inquire what the legal basis for the department's activities was?
No.
All right. So you don't accept that as an accurate characterisation?
Maybe when I was talking to lawyers, yes, but not normally, no.
Okay, but talking to lawyers, you would want to know the legal basis?
That would generally be the reason I'd be talking to them, yeah.
Well, did you talk to lawyers about this program?
I did talk with the Chief Counsel about this program.
This is Annette Mussolino?
Yes.
And did you say to her, what's the legal basis for this?
I can't recall ever putting it in those terms. I remember in January 2017 when the question of legality first arose, I remember asking Ms. Golightly about what happened to the legislation. And then at some point in that period, the DSS position on the legality, but I think there were a number of iterative conversations around this matter, but I don't remember a time where I said that in that definitive term.
What did Ms. Golightly say when you asked what happened to the legislation? What happened about the legislation?
My recollection is that she said when DSS understood more, that at first DSS had thought there would be no engagement with the customer recipient. Once DSS understood that the recipient would have the opportunity through the online portal to provide feedback, they then decided that legislation was not required.
But you must have known it was always a part of this, that the customer would have the opportunity to provide feedback, surely?
I knew that, but apparently DSS, Ms. Golightly told me DSS had thought it was going to happen without engagement with the customer. And so
well, then they couldn't have read the executive minute, could they?
I don't know what was in DSS's mind in January of 2000.
This makes no sense, does it? The executive minute makes it clear that the customer has the opportunity to respond to the ATO data.
So I don't know what happened in DSS in January 2017.
Yes, but we're talking about what they knew in 2015, and they knew perfectly well.
Sorry, 2015, yeah.
Okay, well, anybody who read the minute knew perfectly well that the customer had the opportunity to respond to the PAYG data.
And that's why I cannot answer how it was decided that legislation was not required.
All right. We talked before about what you might have projected to members of the two departments, DHS and DSS, which might have discouraged people from raising issues. Do you think the fact that you were doggedly maintaining that there had been no change to the way income was assessed or overpayments calculated might discourage people who knew perfectly well that that wasn't true from thinking you'd like to hear different?
No.
You see, Ms. Taylor wrote to you explaining that that wasn't true, and you didn't even read the email, it seems.
So I did refer Ms. Taylor's advice, email to seek advice from people who were had more detailed knowledge than me.
Okay, but you said on a number of occasions, made that statement in different contexts, that there has been no change, didn't you?
I said that, yes.
So do you agree that somebody who thought differently would think, well, it's not much use telling the secretary because she's announced several times that there's no change?
No.
All right.
Exhibit 1789 was the exhibit.
The email?
Yes.
All right, can we get that up on the screen? I just want you to have a look at this email.
CTH.3001.0003.774_R.
And do you know a tab number? That's quite hard to read.
Yes, it'll be behind Ms. Campbell's bundle at tab 345. Volume 3, Ms. Campbell. If it's not there, I can hand you a hard copy.
Now, I suppose there are a couple of things about that. I'm looking at, and if we can bring up the Friday, 20th January 2017 email from you,
That is.
which is the third one.
Yes.
Yes. Now, this is an interview that Cassandra Goldie had given, presumably to David Spears, although it's not entirely clear. I thought she said at the end that she was okay with automation as long as it was always beneficial to the recipient. If so, it will be a good line for us to use in the future. We have to make sure it is in accordance with the law, not just beneficial to the recipient, was going to be your line. First of all, it suggests a certain triumphant seizing on something Ms. Goldie said that could be used against ACOS. Is that a correct impression?
No.
And second of all, your assertion that we have to make sure it is in accordance with the law seems rather at odds with your indifference to getting legal advice for long periods.
Well, this is 20 January 2017, and I thought it was in accordance with the law at that time.
Well, making sure it was in accordance with the law doesn't seem to have been one of your priorities, does it?
At that time, I had understood that DSS had advised that it was in accordance with legislative requirements.
All right. Did you, in relation to the Ombudsman's report, can you recall saying at one stage that the Ombudsman's statement that what you were doing was in accordance with legislative requirements would be your referral?
I'm not sure whether it was the Ombudsman's report or Mr Pratt's letter in the Ombudsman report, but I do recall that we, at that time, thought at that fixture that it was in accordance with the law.
Yes, but wasn't it the case that you found the Ombudsman, having conveniently said that it accorded with the legislative requirements, perhaps I should get the actual words up.
Exhibit 7071.
Is the document within the packs?
This will require the Minister's Office's statement, which on my recollection refers to the Ombudsman's report in turn.
Yes, if the document on the left of the screen could be taken down and the second page of the exhibit could be placed on the screen.
Yes, thank you. You'll see on the right-hand side, the Ombudsman found that asking welfare recipients to explain discrepancies identified through data matching is reasonable and appropriate, and that the debts raised by the OCI are accurate, with these debts being based on the information available to DHS at the time the decision is made. That's what you said would be your referral. Do you remember that?
So I don't know whether that referral is in the context of the inquiry from the Canberra Times or in the future. So clearly this was in response to a Canberra Times inquiry?
It certainly was persistently the case that the department alluded to the Ombudsman's report any time there was questioning. That's right, isn't it?
I think the Ombudsman report was raised in response to the questioning.
Mm. And finally, did you meet Mr. Robert yourself while you were DSS Secretary and he was DHS Minister? Did you regularly have meetings with him?
Mr. Robert was also the Minister for the National Disability Insurance Scheme, so I met with him regularly because I was responsible for the National Disability Insurance Scheme.
Okay. One view of things is, going back to 2015, that in order to oblige the two ministers involved, DHS removed references to averaging and substituted the fiction that there'd been no change in what was being done, so that DSS then would no longer press for legislation. You appreciate that that's an available interpretation?
I appreciate that is an available interpretation. I don't agree with it.
You don't agree with it, and you weren't
No.
involved in anything of the kind?
No.
All right. I think that's all I have to ask you. Anything arising out of that, Mr. Gregory?
Yes, one issue in respect of Exhibit 1789. This is behind tab 345, again towards the end of Volume 3. Ms Campbell, you just gave evidence to the Commissioner that as at Friday, 20 January 2017, when you referred in your email to making sure that the automation was in accordance with the law, that you thought that it was lawful because of information conveyed by DSS. Do you have a document which demonstrates that you knew that at that time?
No.
And how can you be confident then that you knew that as at 20 January 2017 when you sent this email?
Because I came back on the 10th of January and that was one of the issues that was being discussed at that time.
What was?
Whether it was legal.
And who were you discussing that with?
Ms. Golightly.
And did she tell you at some point between the 10th and the 20th that it was DSS view that it was legal?
Yes.
I suggest that could not have happened because the advice provided by DSS was dated 24 January 2017.
That may have been the case when it was provided in writing, but I'm sure there had been discussions with Ms. Golightly before then, between DSS and Ms. Golightly.
And in your various conversations with Ms. Golightly, she didn't tell you that the AGS had been approached to provide an advice?
No.
One point I overlooked earlier in respect of the vulnerability indicator for Mr. Corso was that Ms. Miller gave a statement, that is Mr. Corso's mother gave a statement to the Commission, Exhibit 5108, in which she was informed, or which recorded that she was informed that a vulnerability indicator could expire a little over 12 months after it was coded onto the file unless it was reviewed within 2 weeks following the 12 months. That is, there was a system process which took vulnerability indicators off a file unless they were positively reinserted onto the file by officers within DHS. In those circumstances, this would appear to be more of a systemic failure to have a vulnerability indicator on Mr. Corso's file rather than a simple oversight on one occasion, wouldn't it?
I don't know the details of that.
You don't know the details of his file sufficiently to answer that?
No.
But you don't know how vulnerability indicators worked either? Wouldn't this matter quite a lot?
I'm sure up until 2017, when I was the Secretary of DHS, I had a good understanding of how vulnerability indicators worked in the process. But 6 years later, I don't have a good understanding or a recollection of how they worked. I understood that vulnerability indicators indicated that the recipient was vulnerable, but I'm not aware of when they expired or the process for having them renewed.
You see, it does seem a pretty fundamental system failure if a person is found to be vulnerable for the purposes of DHS's dealing with them on day one, and that's automatically removed on day 366, regardless of their state of health.
I can't recall what the arrangements were for the vulnerability indicators at that time.
All right.
Well, perhaps I'll ask that Exhibit 5108 be brought up on the screen. It is Ms. Miller's statement which records at paragraph 83, that's page 11 of the statement, clarification sought on 15 February 2017 about how a vulnerability indicator is placed on a customer's file. And you'll see there that Ms. Monica Bacuzzi, the National Manager of Social Work Services and Community Engagement Officer Program, a position in DHS, was asked that information on that date and provided that response. Can you see that, Ms. Campbell?
Yes.
And if we go over to the next page, the continuation of paragraph 83 and 84 could be called out. Thank you. the content of the information provided between officers within DHS reproduced in paragraph 83 and paragraph 84 conveys that Mr Corso had a vulnerability indicator coded on 5 June 2010 after a job capacity assessment was completed, and that the explanation is that it appears to have auto-ended sometime after a year later in 2011.
That's what the document says, yes.
Yes. And on that basis, you would agree that there's a systemic issue about the recording of vulnerability indicators?
Generally, people who had vulnerabilities were in contact with human services on a regular basis. So I am not able to answer now how the vulnerability indicator system worked in 2015 or even now.
Thank you.
Ms Hogan-Doran.
Commissioner, there's a number of matters that have arisen in the course of Ms Campbell's evidence which go to access to documents and particular documents. I don't think that I need to deal with them directly, but I am seeking further instructions in relation to them and will provide additional information to the Commission by way of assistance. One matter has just been brought to my attention. I just wanted to ask in respect of it. Exhibit 7072 be placed back on the screen, which is the meeting agenda for the DHS DSS Secretary on 3 May 2019. I think, Ms Campbell, you indicated you'd asked for the minutes of the meeting and they'd not been able to provide them to you. Has that been brought up?
Yes.
Do you have a recollection of that meeting being cancelled?
No, but I do have a recollection that many of those meetings were cancelled.
Who was Alana Hempenstall?
She was my EA, my executive assistant.
Would it surprise you if there was a record of Ms Hempenstall confirming that that meeting was cancelled?
No.
Your documents extend to any replacement meeting?
I'm having those questions pursued, Commissioner. In relation to access to materials, Ms Campbell, may we take it that when you say you had requested access to your diaries and you had not been given them, the Commission is to understand that your diaries could not be provided to you in the format that they had been at the time in which you were Secretary of DHS and Secretary of DSS?
Yes.
But that you'd otherwise been given information in the form of an Excel spreadsheet for invitations to and acceptances or declining of meeting invitations?
Yes, unfortunately that didn't capture everything that was in the diary.
For example, it did not capture where you had blocked out time, I think is the matter you raise in your statement.
Yes, and also often it didn't capture meetings with ministers when ministers' offices were not using Outlook.
They're the only matters I'm in a position to raise at this moment, Commissioner.
Mr Flynn.
Sorry, Commissioner. One matter I wish to raise with Ms Campbell by way of re-examination. There's one matter relating to documents that I'll raise at the end.
Sorry, yeah.
Could we please bring up transcript page 42 from today, beginning at line 10?
42 doesn't sound like... I thought we had a running transcript, but...
The version I'm looking at seems to be...
Okay, maybe there's a daily version that
Yes.
works like that.
The passage begins in the time marking, in any event, at around 10:59:25. Go to page 41. 35. Scroll up slightly. Ms. Campbell, do you recall you were asked some questions about the issue of the time frame for passing legislation in time for a 2015 budget measure?
Yes.
And do you recall that at page 41, line 43 to page 41, line 47, you referred to, in that budget, the 2015 budget, there was legislation with respect to the age pension and it was passed. Do you remember that answer?
Yes.
Could I show you two documents, please? I have copies for my learned friends, Miss Hogan-Doran and Mr. Gregory. And
Jess, can you get those documents? Okay.
one for the Commission.
Commissioner, before my friend asks any questions on that, I haven't seen it. I'm just taking some urgent instructions to see if there's any issue that raises matters of public interest.
It's just an explanatory memorandum.
It's an explanatory memorandum. I don't understand the issue.
No, it's all right. I was just trying to confirm that it was one that had been published. That's all.
Yes, we don't have access to ones that haven't been published.
Fair point.
Ms. Campbell, could I ask you to look at the explanatory memorandum, which is a revised explanatory memorandum for the Social Services Legislation Amendment, Fair and Sustainable Pensions Bill 2015. Do you see that on the front page?
Yes.
And do you see on the first substantive page, there's an outline and it says this bill will introduce an important 2015 budget measure improving the fairness and sustainability of the pension system.
Yes.
And it said that the measure will commence on the 1st of January 2017.
Yes.
And if the transcript could be brought up, please, at page 42, line 31. The timestamp is 11 o'clock and 46 seconds. If you could scroll down a bit further, please. Yes. And you see at transcript, page 42, line 31, you say, I know it was passed before the 1st of January 2017 because that's when we implemented it.
Yes.
And if you read the outline in the explanatory memorandum, does that assist you to recall that the issue of rebalancing the asset test parameters by increasing the asset test-free areas and the taper rate by which a pension is reduced once the free areas are exceeded was the budget measure you were referring to in your earlier answers?
Yes, it was.
Could I show you, please? I have copies for my friends. A copy of the an act which bears the same title as the explanatory memorandum you were just looking at, which is the Social Services Legislation Fair and Sustainable Pensions Act 2015.
Yes,
You have that?
I do.
And if you could turn through, please. To the first page of the Act, ignoring the title pages. So the page that says on it, an Act to amend the law relating to Social Security and veterans' entitlements and for related purposes.
Yes.
And you see under that, it says assented to 30 June 2015.
Yes.
And do you understand from that that if that Act was assented to on 30 June 2015, it had been passed before the 30th of June 2015?
Yes.
And was this Act the example of legislation you're referring to in your answer where a budget measure for 2015 that was to commence on the 1st of January 2017 was passed quickly?
It was.
Commissioner, those are the matters I wish to raise.
Would you like those to be exhibits?
Yes.
Okay, any problem with... Yeah?
We would suggest that the tender of those exhibits would infringe parliamentary privilege. If they've been used to refresh your memory, which we don't have any difficulty with, and we accept that it has refreshed it in those terms, but the documents need not be before you.
Why can't a copy of an act be tendered as a matter of historical fact?
I've just raised it for your consideration, Commissioner. I don't put any higher than
Mr
that.
Flynn, I suppose we can just accept that the assent date for the legislation... Are you worried about the explanatory memorandum too on that basis?
They're in the same category, Commissioner.
Do you want to argue about it, or should we just put it on the record that it's accepted, that there was an explanatory memorandum? What did the explanatory memorandum add to the Act being passed on the, assented to on the 30th of June?
That it's a measure for the 2015 budget.
Oh, I see, okay.
Because as I understand the submission, it's that there wasn't enough time to pass.
Yeah, I understand why you want it. I'm just thinking of a way of deflecting arguments about parliamentary privilege, which are seldom fun. Could we perhaps get a typed acknowledgement that the explanatory memorandum indicated that it related to the budget and that the Act was assented to on that date, and that can be the exhibit? Would that do for your purposes?
If we could agree a set of, or even agree a set of facts with the Commonwealth, that would meet the occasion.
Yes, okay. Would that be all right?
Whatever is the way, we will find a solution.
Great, and I'll make it an exhibit when you've got
Thank you,
that solution. Thank you.
And, Your Honour, beg your pardon, Commissioner, the last matter I wish to raise is Ms Campbell put on a supplementary statement, and as we understood the position, all the documents that had been footnoted in that supplementary statement formed part of the tender bundle before you this morning. Our preliminary checking has revealed that at least in a number of cases, the version of the document that has gone in the exhibit bundle is a different document, or it's a subset of the documents that we have referred to in the statement. If I could just illustrate that with reference to one example. It's footnote 22 of Ms Campbell's statement.
Okay, just bear with me a moment. This is the supplementary statement.
Supplementary statement of the 3rd of March 2023.
And just remind me where the supplementary statement was. It's in the supplementary bundle, I'm assuming?
I can't assist.
Oh, I've got it. It's all right. Footnote 22.
Footnote 22.
And that's KCA 00097, etc.
Yes. So that is the statement was prepared with reference to that document number. The document has been tendered with reference to a Commonwealth number, which is, in this case, it is only the cover email.
Okay.
And it lacks a number of attachments that are part of the document bearing the KCA reference. So that is a matter we can raise in correspondence, but the intent being that the form of the documents in the statement
Okay, somewhere along the line, you've just got a covering email, you haven't got the attachments, you want the attachments in.
That's the short story.
Okay. Is there much of that, do you think, or?
We've identified 2 occasions.
Okay, I'm sure it can be fixed.
Yes.
All
Thank
right.
you, Commissioner.
Thank you. Right, Mr Gregory? Yes, thanks, Ms Campbell. You're excused and we will adjourn till, yep.
Commissioner, could I just raise two matters?
Well, you're excused, Ms Campbell. If you want to go, go by all means. Yep.
Commissioner, the Department of Prime Minister and Cabinet will assist by preparing a statement on the Expenditure Review Committee attendance record practice and provide that to the Commission. And the second is that a proposed draft non-publication direction will be sent to the Office of Solicitor Assisting for consideration.
All right, thank you for that. Just a minute. All right, we'll adjourn till 10 o'clock tomorrow. 10 o'clock tomorrow going to work?
Yes.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.